I'm getting. Same order.
Acha, record and order item 35. Learned advocate for the appellant is present. A respondent insurance company is present. It is submitted by the learned advocate for respondent insurance company that the time to deposit the compensation check has expired. Stop. Thus, the time to deposit the compensation check stands extended till 21/8/2026.
I 72. I am for the petitioner. My lord, in application for condonation of delay, my lord. Can two.
Record. Yes, you are for the claimants.
I am for the claimant 3 and 4. My lord, I am respondents. Claimant number 1.
You are for?
Claimant number 1, appellant.
Item 72. 72.
Yes, ma'am. My lord, only 26 days delay, my lord.
Okay.
And 2.
72. Okay. Yes, record an order. Learned advocate for the appellant and learned advocate for respondent number 3 and 4 are present. Service upon others are complete. None appears for the other respondents in spite of service of notice. The application for condonation of delay is taken up for consideration. Heard learned advocate for the appellant and learned advocate for respondent number 3 and 4. Peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Can 2 of 2026 stands disposed. As the appellant number 3 and 4 is represented, service of notice upon respondent number 3 and 4 is dispensed with. Stop. However, service of notice upon respondent number 1 and 2 be caused by personal service through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 1 week.
There is no required by trial court record, my lord. My lord, your lordship, fact of the case is a dispute of the share between the appellant number 1, wife of the deceased, and parents.
The trial court records are dispensed with at this stage. The paper book be filed by the appellant within 4 weeks. Liberty to mention thereafter.
My lord, your lordship, fixed date, any date, my lord.
Anyway, after 4 weeks.
My lord, your lordship, fixed.
This is a case of which year? 25.
25.
So you prepare the paper books and mention. Okay. Let the paper books be prepared. Liberty to mention upon preparation of the paper books.
I am taken up 73, my lord.
73?
70 before your lordship taken up 72 and 73, my lord. Today I am
72 নিয়েছে 73 এর সাথে 74
no, 72.
No, 73 and 74.
No, one outside list matter. One matter you say assign intimoted expert.
Okay. Let the matters be called on, thereafter you mention.
My lord, this is insurance appeal pursuant to my lord's earlier direction, my lord. The entire compensation amount has been deposited. Your lordship will kindly dispose of this.
Can one?
Lordship.
Yes, record an order. Learned advocates for the appellant and learned advocates for the claimant respondents are present. As the appellant insurance company has deposited the entire awarded sum, the ad interim order of stay stands absolute and shall continue till disposal of this appeal. The trial court records be called for at the special messenger cost of the respondents' claimants to be deposited within 1 week. The paper books be
My lord,
prepared.
I have already prepared the paper books on
Ajay,
the
the
basis of
paper,
certified
the
copies
paper
I am
books
filing it.
prepared, be filed.
I
The
have filed
paper
it and
books,
given a
the
copy.
paper books prepared, be kept with the record, copy be served.
I have already served a copy.
Vehicle owner is served.
My lord, vacant nil, my lord, initially I had served at the time of filing of condonation of delays. Subsequently, it has been served to the department, my lord. If not, if your lordship directs, I'll serve it again. Your lordship will, my lord, make it returnable any day.
Okay, service of notice upon the respondent number 3.
Lordship.
No, respondent number 2, my lord.
Respondent number 2
Owner, person number.
be effected by personal service
Lordship.
through register post as well as through the department. Liberty to mention
My lord.
after,
My lord, this is an accident of 2015.
yes.
Only ground is 50 days delay in filing FIR. I have one cross objection on the ground that future prospect is not given. Only one claimant who is the widow, she is a senior citizen, my lord. Kindly fix any date.
After
Even,
4 weeks.
my lord, even in the month of September, fix a date, my lord.
Right.
Only request. In the meantime, let them serve, but kindly fix a date in
Let the
September at
service, the
least.
affected trial court records come, otherwise it will be difficulty.
My lord, these paper books has been prepared on the basis of
No,
certified
you
copies, my lord.
submit the special messenger cost, okay? Let the trial court records come. Mention after 4 weeks.
Grateful to you. একটা condonation আর একটা estate আগে ডিসপোজ হয়ে গেছে হ্যাঁ টু আগে ডিসপোজ হয়ে গেছে শুধু ওয়ান আছে হ্যাঁ
কোথায়?
এটা এই ম্যাটারে শ্রেণীদের
দেওয়া আছে।
75 on behalf of the appellant insurance company. My lord, this is a very, very short matter. I wouldn't have troubled my lord.
Go to Lok Adalat.
No, may I? I would have, but the learned advocate appearing on behalf of the claimants, my lord, not him. He has been briefed in the matter. He is unwell. This will take 2 minutes of my lord's time. There's only error in calculation. Number one, I've taken one additional ground, my lord, which is contributed in negligence. If because of that, my lord,
This can one for.
that is my stay. I've deposited the entire awarded sum before.
Okay, record an order.
My lord, may I?
Yes.
Today at 4 p.m. whenever, if time permits, my lord, if this matter can be disposed of, kindly, my lord.
Mention at 4 p.m. then.
I'm grateful, my lord. Grateful. We are here whenever my lord desires. If it can be taken. Grateful, my lord.
Kindly make it fast.
Pass over.
Your Lordship, item 76, there's an instruction upon me to take instruction from the company. I've already,
Question is, you let it go to Lok Adalat for the settlement. If the matter is settled well and good, otherwise I'll hear it out.
yes, Your Lordship. Your Lordship, kindly send it for the local, we have no issue.
Yes, 76, record an order.
But Your Lordship, today you don't record my appearance because I have not been formally been appointed.
My lord.
That's in process, Your Lordship. 76.
Anyway,
In 76, I am appearing on behalf of the applicant. I have in the
the claimant.
yes, I am for the claimant.
Question is, I am sending the matter to Lok Adalat. Try to settle it. If settlement fails, I shall take it up in the month of September.
Okay, my lord.
Record an order. Learned advocate for the appellant claimant is present. Appellant claimant.
Appellant claimant.
This court is of the view that as it is a claim case and there is a chance of settlement, let this matter go before the Honorable Lok Adalat to be held in the month of September. Fix 16/9/2026 for report of the Lok Adalat and further orders.
Deeply applied.
আমার কাছে নেই। 77 is my appeal, my lord. I have deposited the entire awarded sum before my lord's court. Let the stay be absolute. I shall prepare the paper books. I have the entire
So what is the difficulty to go to Lok Adalat?
driving license.
Recovery order will not be passed.
The recovery order, my lord, I will not be getting it from Lok Adalat. I have the entire set of
Learned advocates for the parties are present, as the entire compensation amount awarded is already deposited by the appellant insurance company. The ad interim order of stay passed earlier is made absolute.
I'm grateful, my lord.
The trial court records be called for at the special message.
No, I have the entire set, my lord. Owner did not contest. It was ex
Trial court
parte.
records.
I have it with me, the entire set of exhibited documents.
Okay. The
For the timing, let it be dispensed with.
trial court records is dispensed with for the time being. The informal paper books be prepared by the appellant
My lord,
within 4 weeks.
my lord.
Liberty to mention thereafter.
My lord will fix up a date in, if possible, in September.
After 4 weeks, you mention. I'll take.
My
it up.
lord, my lord. Grateful, my lord. Deeply obliged. ঠিক আছে হ্যাঁ ঠিক আছে আপনি মেনশন করে করে নেওয়া যাবে।
Okay, not today.
Right. 79 is my appeal, my lord. I have deposited the statutory. There is no delay. This is the,
Respondent has not appeared.
my lord.
Respondent claimant has not appeared.
It's my only stay application, my lord. My execution case is pending before learned trial court at Alipur, my lord. The money has already been deposited. The check is lying deposited before the trial court. Any day it will be disbursed.
Oh, whether
A number
I'm staying the operation.
My
Whether at this stage it can be referred to Lok Adalat.
No. Because this is fraud. This
Oh.
entire case is on fraud.
Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 12/5/2026 passed by learned additional district judge 12th Court Alipur, South 24 Parganas in MSC case number 19 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation amount along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The trial court records be called for at the special.
I have the entire bunch, my lord.
No, but records.
My lord will call for. My lord will call.
Trial court records be called for
In usual course.
and the paper books be prepared on arrival of the trial court records. Service of notice be caused upon the respondents, both personally by registered post as well as through the department by filling up necessary requisites and forms. The liberty to mention after 4 weeks.
Lordship, one humble prayer, my lord. Yes. The execution case number is 69 of 2026, my lord.
State the award.
Let that my money will be dispersed, my lord.
Okay.
The check is lying deposited.
As there is a stay of operation of the judgment and award passed by the learned trial court, the execution case in connection with the said judgment and award shall remain stayed for a period of 5 weeks.
Till disposal of the application, my lord.
I've made it 5 weeks. So prior to that, you obtain extension, you deposit.
My lord.
And thereafter.
My lord, deeply obliged, my lord. I'm grateful.
My lord, item number 78, my lord.
78, yes.
My lord, application for stay, my lord.
Yes, call item 78.
আমার 1 মিনিট দেরি হয়েছে করতে পারবো না আমি
Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 28th day of April 2026, passed by learned additional district judge, first track, first court Bardhaman, Purbo Bardhaman, in MSC case number 20 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The trial court records be called for at the special messenger cost of the appellant to be deposited within 1 week. The paper books be prepared on arrival of the trial court records. Stop. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. Liberty to mention after 4 weeks.
I'm grateful, my lord.
My lord, in this matter, I am appearing for the claimant's respondents, my lord.
My lord, pursuant to the direction of the Honorable Court, the entire awarded sum is deposited. Your lordship will kindly dispose of this.
So it can be settled.
My lord,
Quantum is under challenge.
my lord, quantum is also under challenge. My lord, what I say, it is an injury case. There has been no loss of income. But
Anyway, you settle it. Okay, try to settle it. Thereafter, I shall take it up. Oh, but you have deposited the entire awarded sum. Okay. Record an order.
I do not know, my lord, whether it can be settled, my lord.
Very well. I shall. If it is not settled, your remedy is not.
I am still
over.
in service, so I cannot get anything.
Okay.
That is
Learned
their point.
advocates for the appellant and learned advocate for the claimant respondent are present.
No.
As the entire compensation amount is deposited, the ad interim order of stay shall continue till disposal of this appeal. Stop. However, considering the facts of the case, this court is of the view that as there is any chance of settlement, let this matter go before the National Lok Adalat to be held in the month of December. Fixed 16/9/2026 for report of the Lok Adalat and further orders.
my lord, Lok Adalat to be held in the month
Probably in the month of 12th September.
লোক আদালত কি এটা করবে মেঘমা?
হ্যাঁ করবে না কেন
করবে।
সবকটা
আচ্ছা,
complete
my lord,
করবে।
I have filed one cross objection.
এই দেখো।
Yes, entire thing. Entire settlement means entire.
Cross objection is not appearing in the list.
Acha.
Your lordship kindly.
The cross objection be also sent along with the appeal
Yes,
to Lok Adalat.
COT number 32 of 2026. And my lord, I am filing the paper book. Your lordship
Acha, the
kindly
paper
record
books file be kept with the record.
COT. কোনটা? 81. কোনটা?
This is my appeal, man. Insurance company.
হ্যাঁ, এইটা কথা।
I have deposited the statutory amount, 25,000. I pay for a stay, man.
হ্যাঁ, 32 to
And I have served to the caveator. I have served the notice to the caveator.
Notice upon the caveator is served.
I served, man. Yes.
File your affidavit of service.
On the next day, I will file.
Yes. Learned advocate for the appellant is present. None appears for the caveator in spite of service of notice. The application for stay is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 17 November 2025, passed by learned additional district judge, first track, first court, Tomlok, Purbo Medinipur, in MSC case number 118 of 2022 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum within entire awarded sum, including interest, within 5 weeks.
Within 6 weeks, man.
No, 5 weeks. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The the trial court records be called for at the special messenger
No, my lord, in usual course, like.
or for the claimant.
I'm for the claimant.
Can you record your appearance?
You also kindly direct the claimant to file the paperwork.
Just a minute. The trial court records we call for at the special messenger cost of the claimant respondent. No, at his special messenger cost.
He will pay.
Okay. Special messenger cost of the respondent to be deposited within 1 week. But prior to that, you go to Lok Adalat. Okay. If settlement fails, I'll take it up. Very well, I'll take it up. I'm passing the direction also.
They are releasing the file after 2 months.
No, you just, I shall direct them to expedite.
Your lordship's directed, the matter is not appeared in the local law. I have faced this also.
The informal paper books be prepared on arrival of the trial court records.
On arrival, I have the every certificate.
No, better let the paper books be prepared. Okay, you have not prepared the paper books.
Prepare the paper book. I have the every entire documents is with me.
Okay, then prepare. Okay. However, as this matter as it is a claim case and has a chance of settlement, let this matter go before the National Lok Adalat to be held in the month of September. Fix 17/9/2026 for report of the Lok Adalat and further orders. By that time, you prepare the paper books. Okay. If the matter is settled before Lok Adalat, well and good. Otherwise, I shall take up the matter. এই নামটা রেকর্ড করে নেবেন দুজনের
82 and 83 I paid not to the my lord. 82 and 83 I paid not to the my lord.
Yes, item
82 not to the my lord.
Okay.
My lord, I have a little pair, my lord, to be mentioned and to hearing madam.
No, which matter? No,
To be mentioned.
no, which matter you want?
I have mentioned madam.
Very well.
From there. Yes.
Correction. Item number 3.
My lord, I am for the claimant respondent. There is a typographical error in this order. Sir, এটা শুধু এখানে
দেখি।
এসে কি আছে?
কেস নাম্বারটা কি হবে? SAT wrongly typed হয়েছে। Actually SA হবে, SA 98 of 2000। ঠিক আছে?
আমরা ওখানে কারেকশন
এখানে লিস্টেড দেখি। The matter is put up for necessary rectification of the cause title, case number, in order dated 13/8/2026. In the case number, instead of FMA 3197 of 2013, it is mentioned as SAT 3197 of 2013. Let the mistake be rectified.
Next, item number 2, 4.
My lord, one prayer, my lord. Your lordship's one matter has been disposed of.
Which one?
Item number 17/18, my lord, one matter. ও এটা একটা আছে কারেকশন আছে আচ্ছা ঠিক আছে কারেকশনটা হয়ে যাবে
Item number 4.
Item 4 কি কারেকশন আছে এতে? The matter is put up for necessary rectification of the case number in order dated 12/8/2026. In order dated 12/8/2026, the case number is mentioned SAT 98 of 2023 instead of SA 98 of 2023. Let necessary rectification be made.
ক্লার্ক নাম দিয়ে দিচ্ছে। এখন যেটা হলো 4 নম্বর 4 নম্বর
5 minutes.
This is the disposal of
Lordship will come to page 8.
দেখি
Number 8. Yes, number 8.
এই 6-7 কি হলো?
Not the first paragraph. Not the
second paragraph.
second paragraph. Hence, this appeal stand disposed of lot. Judgment passed by land. This
Fourth line.
the claimants, appellants, respondents are entitled to rupees 38 lakhs along from the date of communication of this order. Here, not
Okay, entitled to,
the interest has not been.
no, just below that interest is there.
There was a direct
Okay, that will be
deposit.
deleted, entitled to 38 lakhs. From the date of, not from the date of communication of this order. That has to be rectified.
30
The appellant, no, that appellant Reliance company, they have been directed
to deposit
along with
but not
interest.
to pay.
No, deposit. That is clarified.
So unless your loss is direct not to pay interest, they will not pay interest.
No.
38 lakhs along with 5% interest from
Yes, record an order.
date of filing of the
Learned advocates for the parties are present. This matter is put up for necessary clarification and rectification of judgment and order dated August 11, 2026. In page 8, second paragraph of the judgment and order, in the sentence, the appellant Reliance General Insurance Company Limited shall deposit rupees 38 lakh along with interest at the rate of 5% per annum from the date of filing claim case till deposit stands rectified as the appellant Reliance General Insurance Company Limited shall deposit rupees 38 lakh along with interest at the rate of acha ওটা কেটে দিন in page 8 second paragraph it is clarified that the sentence, hence this appeal FMA 1050 of 2024 stands disposed. Judgment and award dated 10/3/2024 passed by learned additional district judge second court Islampur, Uttar Dinajpur stands modified to the extent that the claimants respondents are entitled to rupees 38 lakh from the date of communication of this order is rectified to the extent that from the date of communication of this order shall stand deleted. Stop.
Here, logically distant lot.
It is further clarified
along with interest
that the compensation shall include interest at the rate of 5% per annum from the date of filing claim case till August 11, 2026. Yes, till August 11, 2026. Other contents of the order shall remain unaltered.
My lord, may I mention one matter, my lord, 17 and 18 today's list, my lord, your lordship dispose of this matter. but the direction is there to submit the ad valorem court fees report with the office of the learned registrar general, my lord. I cannot, my lord, until and unless my the record sent down to the trial court, my lord. I can put, my lord, the special messenger cost by tomorrow. Your lordship is kindly direct.
That has to be extended.
No order is there, my lord. Your lordship is kindly direct freshly that by tomorrow I will send, I will put the special messenger cost to send.
Okay, I shall order that.
Item number 17 and 18.
Yes.
Extension of interim order.
Extension of interim order matter appearing in the list. Then, so no scope to take it up. It is not appearing in the list.
Tomorrow.
No. Tomorrow the matter will appear in the list.
Yes, in the date on 10 March. That after the matter didn't appear in the list, but
So let you wait. If it does not appear, you mention. No. Question is let it appear in the list.
I am saying let the matter appear extension of interim order tomorrow.
Okay, you give the slip.
Item number 17 and 18.
That's that. যেটা payment করলো। ওটা
17 and 18.
Yes.
Yes. Learned advocates for the parties are present. This matter was disposed by judgment and order dated.
My lord. My lord,
My lord.
my lord, I am
My lord, order date বলবো। Order date 20
কত? 24।
You should come with your materials and weapons in the hand. Otherwise, you cannot fight the battle.
I apologize for that, my lord.
Empty hands, how can you fight the battle?
Sorry, my order date একটু দেন। হয়ে গেছে। দাদা বার করে দিয়েছে।
Yes, you have a copy of the order, Mr. Singh?
It's not supposed to be taken.
It is under the heading to be mentioned. That is the problem.
Acha, 24, 2026. The trial court records shall be sent back forthwith upon payment of special messenger cost by the appellant by
tomorrow. They have already deposited.
by 19/8/2026. আচ্ছা, let it be 28 করে দিন, 28/2026.
Not grateful, my lord.
Tentative fixed order. Item number 6.
I am appearing on behalf of the appellant insurance company. I have preferred the appeal, my lord, mainly on the point of quantum. The income I've disputed
So
the.
go and settle the matter. It is a matter of quantum.
My lord will kindly no, because a minute. I have already got the order of pay and recovery. Since that pay and recovery issue is involved in this, it is difficult to get it settled in Lok Adalat. Company cannot, because that 149(2) issue is there.
Pay and recovery is already there.
I already have it. But if I go to Lok Adalat, my lord, that there will be a difficulty.
No, that order will not be altered. That will remain.
Who knows why take the chance, my lord? It's already there. Let it be. My lord will kindly hear it out. I have disputed the quantum, my lord. It's on income and general damages. The income, my lord, this is an accident of 2020 COVID period. The victim, my lord, he was aged about 60 years and he was dashed by a tanker.
Yes.
His widow, son and daughter, 3 claimants, they filed the claim case.
Yes.
And it is the case of the claimants, my lord, that the victim was earning about 15,000 per month as a road roller driver.
Yes.
In the learned trial judge, my lord, took the income to be 10,000. It has been dealt with, my lord, at page number 30 of the paper book, the income.
Because no evidence was adduced.
Yes, evidence was adduced, my lord. The employer, I'll be candid before my lord, issued one certificate, my lord, in the year 2024. After 4 years,
Page?
the my lord is asking about the certificate.
Yes.
It's at page 74. The accident took place in the year 2020, and this certificate was issued in the year 2024. 4 years after the accident. So this is this we disputed, and learned trial judge, my lord, took the income to be 10,000, which has been dealt with at page number 30, 29 to 30. The employer, my lord,
Yes.
deposed as PW3. The evidence of the employer is at page, it's at page 20 to 21, my lord.
Yes. Page 21.
2021.
Yes.
The employer came and said that as a road roller driver, page 20, that the victim, he was being paid a salary of 15,000 per month, and had also referred to the certificate that at page 74, my lord, exhibit 10. And thereafter, my lord, at page 21, why I dispute this salary. This employer, my lord, knowingly says at page 21, to drive the roller, that is the road roller, there is no necessity to carry driving license. This is against the law, because law says that road roller, it's a light motor vehicle and the license is mandatory. I'll show it. So in my it's my case, my lord, that this 10,000 taken by the learned trial judge, my lord, this is also excessive, but it should not be 15,000, whatever it is, on the basis of a certificate which was issued 4 years after the accident, and also on the basis of the evidence of this employer, which is the ground of their cross objection. Your lordship will kindly see Motor Vehicles Act, my lord. The definitions, my lord.
Yes, let us see.
Is
69 of 2026.
execution case. My lord, 21. I have put in a star, my lord, with pen.
Yes.
Light motor vehicles means a transport vehicle or omnibus, the gross vehicle weight of either of which, or a motor car or tractor or road roller, the unladen weight of which, of any of which, does not exceed 7,000. So for a light motor vehicle, my lord, we need to carry the driving license. So for the tractor also, driving a road roller also, my lord, we need to, the license is required. So the employer knowingly comes up and deposes that it is not required. So this is absolutely gross wrong. So this is my one ground. My lord will kindly come to page 30. I wouldn't take much of my lord's time. My lord will kindly come to page 30. Page 29, last paragraph. Page 29, last paragraph, my lord.
Yes.
From the record, it appears that one Umesh Thakur has been examined in the case of claimant's petitioners who identify himself as the owner of the earth movers, where Salim Hussain was a road roller under him. And he used to pay the said Salim Hussain to the tune of 15,000 per month. In this regard, both the parties have submitted on their respective angles, but from their submission, it has come out that the owner of the earth mover, that is Umesh Thakur, fails to produce any document that he used to pay 15,000 per month, save and except the certificate issued by him, which had been marked as Exhibit 10. Exhibit 10, from Exhibit 10, nothing has been proved that the owner of the earth mover was paying Salim Hussain at the rate of 15,000 per month. No income tax file nor any other document have been
What is
filed.
the business of this person, this Umesh Thakur, what is the nature of business?
It was this earth movers, Thakur, general order supplier, equipment and general order supplier, page 74. That is what that
74.
certificate says. 74.
No, his occupation is Thakur Earth Movers,
Yes,
equipment and general order
yes,
suppliers.
yes.
Road roller operator.
Road roller. It was just merely a statement after 4 years, my lord, that the victim was being paid 15,000 per month. The learned trial judge, my lord, took it to be 10,000, which is very much just, need not be interfered with. So thereafter, the learned trial judge, my lord, so far as the, where was it? No income tax nor any other document have been filed here to substantiate the claim of the owner of the earth mover. Naturally, the evidence of the owner of the truck driver is very weak piece of evidence upon which we should not rely upon. On the contrary, when it has been depicted from the evidence that Salim Hussain was able-bodied and used to work under PW3 Umesh Thakur, certainly he had some income, and that income may be 10,000 per month. So this entire observation, my lord, in my view, my lord, it's just. Now at page 30.
Your challenge is what? Only quantum.
Quantum, income and general damages. General damages at page 32, my lord, will kindly come to once.
General damages, how much is awarded?
2,50,000 was granted.
No,
And
general damages?
2,50,000 total was granted.
General damages?
Yes, page 32. My lord will kindly make it 84,000, my lord, in place of 2,50,000. Page 32, my lord.
Yes.
Third paragraph. Therefore, the general damages faced by the present claimants due to the death of the victim would be 25,000 plus 2 lakh plus 25,000. So it's a total 2,50,000.
Total compensation calculated is 10,42,000.
10,42,000, my lord.
Total compensation.
Yes, all other things are in accordance with law. Only as far as this general damages, my lord, it's concerned, 2,50,000 was granted and it should be 84,000. This is my entire submission, and I have already been granted the liberty to recover. So let that remain.
That remains because legal owner has not come.
Yes, and I have also given evidence. So let that remain. I'm grateful, my lord. My lord will also, in my lord's order, my lord will record that. Let that remain, and it's not interfered with that pay and recovery, my lord. Grateful.
Yes.
Lord, in this case, my lord, kindly see the evidence of my lord PW1 in the cross-examination, page 15, my lord. My lord, from bottom, page 15, from bottom, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9. On the line, 9 line. My lord, I did not submit the DL stand in the name of my husband in this case. I cannot show the driving license stand in the name of my husband before this court. Being a driver, the income of my husband was 15,000 per month. He used to, my lord, kindly marked it. He used to pay rupees 10,000 per month to me, and 5,000 was kept in the custody of my deceased husband every month. My husband has no bank account. He used to receive salary in cash. The accident of my husband was received from the side of from the side of the police. On the date of accident, my husband was on right footing while the offending vehicle dashed him. My lord, kindly marked it, my lord. 10,000 was every month was giving to the wife to run the family, my lord. And my lord, kindly see here, your lordships will find my lord, page 30, my lord, the conclusion part. My lord, I am placing before your lordship, my lord, so far, my lord, starting, my lord, so far, third paragraph. So far the income of the deceased victim is concerned, it has been mentioned in the application for compensation that the income of the deceased victim was rupees 15,000 per month and he was a driver of road roller. To that effect, the claimants have examined the employer of the deceased victim, but no such document have been filed by the claimant in support of the salary actual received by the deceased victim. In this regard, on behalf of OP Insurance Company, due the attention of this court, when the present claimants have failed to produce any document regarding salary slip or bank account transaction statement or attendance registers to show that the deceased was an employee of the employer who was examined in the present case. However, amount in respect of income of the deceased victim has been shown by the claimant in the claim application is not proper. Not only that, no driving license was produced or any other related documents have been shown by the claimant to prove that the deceased was a driver of heavy earth movers by profession. So the claim of rupees 15,000 per month to be the salary of the deceased is not correct. It is fact that though the claimant have examined Sri Umesh Thakur as PW3 who
Which
claimed
paragraph you are reading? Page 30.
page 30, but bottom portion.
Yes.
Manot, kindly see bottom portion. It is fact. Manot, last 3 lines. It is fact that though the claimant have examined Sri Umesh Thakur as PW3 who claimed to be the owner of Thakurat movers who proves the salary certificate exhibit 10, but from the cross examination it has come out that being the owner of Thakurat movers, he did not file any trade license or to file any document showing PF register of the employees or any document to show about the maintain the ESI register of the employees. Therefore, when the employee himself fails to produce any document show that the victim deceased was an employee under him, the income certificate exhibit 10 does not bear any meaning. No other documents have been produced and proved on behalf of the claimants to show that the actual income of the deceased victim and absence of any such reliable documents, it is not possible to say that the victim deceased used to earn rupees 15,000 per month. On the contrary, being an able-bodied person, when the victim deceased used to maintain his family in common prudence, it can be said that the victim deceased has some income of his own that could have been to the extent of 10,000 per month. This, my lord, logic has been given by the tribunal below in assessing, my lord, rupees 10,000. The fact is that the person has come on dock, my lord, prove the salary certificate.
Any future prospect was taken?
Yes, that has been
10%.
10%.
As per age.
As per age, my lord, 10%.
And 1/3 personal deduction.
Yes, that has been done. The widow stated that 10,000 was given to her, my lord, during his lifetime to run the family.
Let us see the evidence of PW3.
PW3. My lord, page 20. I am the owner of Thakurat movers. My lord, got it?
Yes.
I am the owner of Thakurat movers, Dhulagarh in the district of Howrah. To show my identity, I have filed photocopy of my Aadhaar card. Selim Hussain was the roller driver working under me. On 24 September 2020, he met an accident and subsequently he succumbed to his injuries. As a roller driver, that Selim Hussain used to earn rupees 15,000 per month. This is the income certificate issued by me. This certificate was issued as per prayer of the claimant parties. That is with objection. This photocopy of trade license of our company, Mark Exhibit 11. My lord, trade license has been produced. I am the owner of Thakur Art Movers. The company is running for about 15 years. I have 15 years trade license with me, but I did not file my trade license before this court. At this moment, 10 to 15 persons were working under me. The person, namely Selim Hussain, was working under me at the relevant point of time. 8 persons were working under me at the relevant time, on the date of accident. I am maintaining GST to run my business. I do not maintain PF register of the employees. My lord, this is below 10. This is below 10. So PF register is not mandatory. Your lordship knows that. And at the initial stage, I used to pay salary by hand, but at this moment, I am the payment salary to employees through digital media. Rupees 15,000 was the salary of Selim Hussain when he died. He was working under me at about 8 years. Thereafter, your lordship, kindly see my lord page 21. To drive the roller, there is no necessity to carry driving license as per our business resolution. We may hold an employee up to age of 50 years. We may allow any person exceeding the age of 50 years if he wants to stay with our company. I am not aware at the time of death what was the death of Selim Hussain. It is not fact that whatever certificate issued to Selim is absolutely false. In order to give facility to the claimant, it is not a fact that at the time of death, Selim Hussain was about 60 years. He was not working under me. My lord, that is all denial, my lord.
Yes, anything else?
No.
Yes, record and order. না আমি দিয়ে দিচ্ছি এখন learned advocates for the parties are present, hard learned advocates. The appellant before this court was a claimant in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 16/12/2025 passed by learned judge bench 6 City Civil Court Calcutta in MSC case number 351 of 2020. Stop. The case of the claimant before the learned trial judge may be summed up thus. On 24/9/2020 at about 9:35 a.m. on Andul Road near Alampur More, the victim Selim Hussain, aged about 60 years, going to Andul Road near Alampur More at the same time, the offending vehicle being a tanker bearing registration number WB76B-0034 was proceeding at a high speed in a rash and negligent manner dash the victim. Stop. As a result, the victim suffered serious injury and was removed to Gaberia Hospital, where he was declared dead. Stop. Pursuant to the filing of this case, notice was issued upon the opposite parties. Opposite party vehicle owner did not contest the case. Stop. However, opposite party National Insurance Company Limited contested the case by filing written statement. Stop. Evidence was adduced. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 33. ঠিক আছে, folded. Ordered, hence ordered. The appellant insurance company being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. Stop. The claimant respondents, being also aggrieved by the quantum of compensation awarded by the learned trial judge, has filed the cross objection. Stop. The ground of challenge by the appellant is that the income considered by the learned trial judge for computing the compensation is excessive. Learned advocate for the insurance company submits that without any relevant documents, the learned trial judge ought not to have considered the monthly income of rupees 10,000 per month. Stop. Learned advocate for the claimant respondent submits that the evidence of PW1 claimant will go to show that the victim is to earn rupees 15,000 per month. Learned advocate draws attention to the evidence of PW1 wherein the said witness stated that the income of the victim was rupees 15,000 per month and he used to pay rupees 10,000 per month to her and rupees 5,000 was kept in the custody of the victim. Learned advocate further submits that the employer of the victim came and deposed, thus the income ought to have been considered rupees 15,000 per month. আচ্ছা ওর আগে একটা কথা লিখে দেবেন learned advocate for the insurance company also submits that the compensation granted on account of general damages of being rupees 2,50,000 is excessive. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that the claimant PW1, being the wife of the victim, in her cross-examination clearly stated that her husband's income was rupees 15,000 per month. She further stated that her husband used to pay rupees 10,000 per month to her and rupees 5,000 was kept with him. Stop. The specific statement made in the cross-examination will go to show that the income of the victim was rupees 15,000 per month. Stop. When a person dies and there is no sufficient document, there is no document to prove the income, in the event the evidence, oral evidence of the victim's family inspires confidence in the minds of court regarding income and the occupation, the said income and occupation can be accepted by the court. In the instant case, from the evidence of PW1 itself, it is sufficient to consider and hold that the victim was a driver and his monthly income was rupees 15,000. Stop. Further, PW3 has specifically stated in his cross-examination that the victim was his employee. He further stated the number of employees who is to work under him, the trade license which is filed in the court. Stop. Which will further strengthen the case of the claimants of the victim being a driver of a road roller and the victim earning rupees 15,000 per month. Stop. Thus, this court is of the view that the income of the victim should be considered rupees 15,000 per month. In the event the income of the victim is considered rupees 15,000 per month, 1/3 being deducted on account of personal expenses, the net monthly income comes to rupees 10,000. 10% being added on account of future prospect, the total monthly income comes to rupees 11,000. Thus, the annual dependency loss comes to rupees 1,32,000.
No, no, our calculation ঠিক আছে। 6 2020 মানে 6 বছর।
The multiplier of 9 being applied annual income comes how much?
1,32,000.
1,32,000.
Yes, yes. Middle portion, my lord, kindly.
So why you stated 1,98,000? No, total, you see, 15,000.
Yes, yes.
That is 1/3.
10,000.
1/3, that is 5,000 goes
Yes.
personal expenses, 10,000.
10,000.
Future prospect 1,000, that is 11,000.
Yes, yes.
11,000 multiplied by 12. It is 1,32,000. Okay. The multiplier of 9 being added, the compensation comes to rupees 11,88,000. Further, the claimants are entitled to compensation on account of general damages, rupees 84,000. Stop. Thus, total compensation comes to rupees 12,72,000. Stop. By arithmetical calculation. However, this court is of the view that compensation of rupees 12,50,000 is just and reasonable. Hence, the appellant National Insurance Company, hence the respondents, claimants, hence this appeal, FMA 515 of 2026, along with COT 51 of 2026, stands disposed. The judgment and award dated 16/11/2025 stands modified to the extent that the claimants respondents are entitled to compensation of rupees 12,50,000 from the appellant National Insurance Company Limited. Stop.
Along with, my lord, interest.
The appellant National Insurance Company Limited shall deposit rupees 12,50,000 along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by the learned trial court is already deposited, the balance deposit be made. The claimants, respondents will be entitled to withdraw the compensation upon compliance of necessary formalities.
My right to recovery, my lord.
Okay.
Page 33.
With regard to right of recovery by the appellant insurance company, as no appeal is preferred by the vehicle owner, respondent number 2, this court does not find
Respondent number 4.
respondent number 4 vehicle owner, the findings is not interfered with.
Great.
The deficit court fees be paid within 4 weeks. The trial court records be sent back by special messenger post to be put in by the respondents claimants within 1 week.
Deeply obliged, my lord.
Before your lordship takes up, item number fixed matter. Today, item number 35 is appearing as to be mentioned. My learned senior friend in the morning mentioned the matter, extended the time, but there is a correction is required. So far, I am for the appellant. So far, appellant is concerned. Your lordship, let the matter be placed tomorrow as to be mentioned. Also,
আচ্ছা কালকে এটাকে টু বি মেনশনে দিয়ে দেবেন তো
35 টা
35টা
35 35 ওটা সকালবেলা করে নিয়ে চলে গেছে স্যার।
আচ্ছা 12 PM ফিক্সড ম্যাটার আছে বোথ সাইডস আচ্ছা আচ্ছা 9 10 আছে বোথ সাইডস
The matter appears tomorrow as to be mentioned.
হ্যাঁ ওটাকে টু বি মেনশনে দিয়ে দেবেন
বুঝেছ মন্ডলদা 35 টা সন্ধ্যা নাই হ্যাঁ 2 মিনিট স্যার সকালে মেনশন করে নিয়ে চলে গেছে।
No, you are appearing for the insurance company.
I am for the appellant.
So what is to be rectified there?
Rectified only that the surname of the claim one of the appellant.
So for that, did you file any application?
I have not yet filed any
So
application.
that you do, then it will be.
It is not necessary. You also kindly there's
Had it been in mistake on my part, recording or something?
No.
Because if something is there, it has to be brought by way of application.
After she got married,
Now the question is that should be brought on by way of affidavit.
fix the matter any day.
You file an application.
I will file the
File and immediately you mentioned it will be included.
Instead of that, man, you also kindly fix the matter on.
Okay, better file an application today itself. If you can bring your client, the matter will be included tomorrow and you give the slip.
Aadhaar card দিয়ে করেছে I am grateful.
যে অর্ডারটা আছে ওটা থাকবে 21 তারিখে টাকা জমা দেবে
100 ওকে
12টার ম্যাটার বোথ সাইডস আছে
এটাও 12টাতেই আছে ও 30
না বোথ সাইড থাকলে স্টার্ট করে দিচ্ছি ও 35টাকে ওরা অ্যাপ্লিকেশন ফাইল করুক ওটা অ্যাপ্লিকেশনটা সমেত দিয়ে দেবে
Nine, my lord, is my appeal and 10 is my learned friend's separate appeal.
So is there any chance of settlement?
I have preferred this appeal, my lord, on the ground of contributory negligence on the part of the victim, because at the time of accident, my lord, he was a minor and he was driving without a license, the scooty of his sister. That, my lord, will find from the evidence.
Kindly ignore that that is something missing, my lord. I think you have to take. I have already started my lord on appealing for it.
My lord will kindly come to the, as far as the minor, that accident took place, my lord, between a scooty and a Bolero car. Victim, my lord, he was aged 17 years, a minor, and he was driving his sister's scooty when he met with an accident with this Bolero car. This Bolero car is insured with Oriental Insurance Company, that is my client. And the parent,
car.
my lord?
No, Bolero car was the scooter.
No, Bolero
Offending vehicle.
is the offending vehicle.
Okay.
The award, my lord, it was passed against Oriental Insurance, and Oriental was directed to satisfy this award of 3,50,000. It's under 166. Oriental was directed to satisfy this award of 3,54,000, my lord, within 2 months, along with 6% interest. In default, further 9% interest was levied upon the insurance company. As far as this contributory negligence on the part of the victim, that is my sole ground of appeal, my lord. My lord will kindly come to their claim application, my lord. It is at page number, the very starting page, my lord, page 1. Page 1, my lord, the age of the person is 17 years. It's their case that the victim was aged 17 years. and the victim was driving, that my lord will find from page number 5 of the paper book, my lord. Serial number 23. Any other information?
Page number
5.
5.
On the fateful day,
Yes.
page number 5, my lord, on the fateful day of accident, 12/12/2016, at about 14:15 hours, while the deceased was driving his sister's scooty bearing number such and such, was proceeding towards Krishnagar's side. So it's their case also that there's no denial that the victim was admittedly he was driving his sister's scooty at the time of accident, and he was aged 17 years. Now I'll straightway take my lord to the seizure list. The seizure list, my lord, it's at page number 51. It has been exhibited. আচ্ছা এর ট্রায়াল কোর্ট রেকর্ডস আছে? তাহলে ওইটা মাই লর্ডকে দিলে ভালো, এটা একটু বোঝা যাচ্ছে না। Page 51, my lord, it's a little it's not very clear in my copy, legible.
Page 51.
I'll show it from the trial court record. এই যে 7. আপনি আমার এই যে এখান থেকে তাই the seizure list, the first seizure list, page 51 of my paper book, and there my lord will see 2 vehicles were seized. One small vehicle, that is the Bolero car, and one scooty, which the victim was driving. Thereafter, my lord, at page 52, the number of the Bolero car was WB58A A4298. My lord will see
Page.
the next page, 52, my lord.
52.
The documents in
This is a seizure list.
my lord,
Yes,
52 is also a seizure list. So
Yes.
the documents in connection with the Bolero car, my lord, being the registration certificate,
Yes.
the insurance policy, the
That is
tax
53.
receipt. That is 52 in my paper book, my lord.
No, I'm going through the records, trial court records.
My lord, my lord. The next seizure list, my lord.
That is the documents.
The documents, they were seized. They were in connection with the Bolero car. And thereafter, the third seizure list, my lord. Therein, my lord, the driving license of the driver of the offending Bolero car that was seized. So these are the 3 seizure lists, my lord, which show that the scooty was seized, as well as the documents in connection with the Bolero car and the driving license of the offending driver. But nowhere it says that either the learner's license of the victim or has to be, or it was not seized. And he cannot have anything other than learner's license. It was neither seized nor produced before the learned trial court. It's my case, my lord, that the victim did not have any driving license, and the owner, who was his sister, my lord, and is also a respondent in this case, my lord. She is respondent number. She is respondent number 4, my lord. She knowingly allowed her scooty to be driven by the victim, my lord, who did not have any license to drive the said scooty at the time of accident. কি করব? And accordingly, my lord, it's my case that the victim contributed to his accident to a certain percentage by driving the scooty without a driving license. He was a minor, admittedly, and he was driving without any driving license.
Yes.
In the award, my lord, issues were not framed. This issue has not been dealt with. So this issue of no driving license and contributory negligence, it has to be read read as a whole.
That issue was framed.
No.
Issue of driving license
I'll just check
or
once.
contributory negligence.
I will just check once. The issues, my lord, it's at page 22 of the paper book. The victim. আমার সাথে পেজ একই তো my lord? আচ্ছা victim ও নতুন কি পেজ চেঞ্জ হয়েছে না একই একই No, issues were not framed. But still fact remains, my lord, that the victim did not have a driving license at the time of accident. It was not seized, neither produced before the learned trial court. And the owner of the scooty was present.
Owner of the scooty appeared before the court.
Owner of the scooty did not appear. The father appeared. He is one of the parents filed the claim application, and the owner of the scooty is the sister. She knowingly, my lord, she allowed her brother to drive the vehicle without the driving license.
Yes.
This is my sole case, my lord. The award, my lord, the other thing, the income, my lord.
Compensation.
My lord, the compensation.
Minor.
Is a minor.
So a notional income.
3,000 was taken. Since the income was not proved, my lord, that is at page number 28, my lord. Since though the claimants stated that victim was a salesman come manager, and he was earning 6,000 rupees, my lord, but it was
3,000 was considered.
3,000 was considered, my lord. It starts at page 27. There in the age also it shows that he was a minor, 17 years. So 3,000 it's just. But they are entitled to future prospect. I must admit, 40% future prospect they are entitled to.
So that is considered.
No, that had not been granted. Future prospect. That had not been granted, and the interest, my lord, it should come down to 6% because both penal and this simple interest both were granted. So this is my and the assessment of the award, my lord. It's at page 28.
So general damages, how much was awarded?
A total sum of rupees 30,000 was granted. He was a bachelor minor.
Okay.
This is my
Ideal consortium granted.
No. So all I pray, my lord, that certain percentage of the victims' contributory negligence, my lord, that should be deducted from this award. This is my ground, one of the grounds, and other is interest, my lord. And in my written statement, my lord, the supplementary, I have taken the usual ground, my lord, but I have taken, even if I have not taken a specific plea, but usual ground I have taken, it's at paragraph number 12, my lord. Fact still remains that he was a minor and he was driving. He is not supposed to drive the vehicle, my lord, before 18 years of age. He was driving. That is also wrong.
Learner's license was not seized.
Nothing. And in any event, my lord, he was not even 18. So he won't be having the learner's license also. He was not even 18. He was a minor. Under no circumstances, my lord, Under no circumstances, my lord, he should have.
It is the claimant's case that he was 17 years.
Yes, yes. It's admittedly he was 17. The learned trial court, my lord, had also observed that he was 17 years. That is at page 27, my lord. Last but one paragraph. There is no dispute that he was a minor. So under no circumstances, my lord, though I said that his learner's license should have been there, but I stand corrected. He was not entitled to drive at all. At all. And had any license been given to him, that also would have been against the law because he was a minor. I'm grateful, my lord. That is all.
Yes.
The scooty was insured with New India, my lord.
And for the respondent number 5, my lord, New Indian Insurance Company.
The scooty was insured with him. I don't have any case against New India.
What is not against the New India?
Only as far as the victims, that percentage, my lord, contributory negligence, that should be deducted. I'm grateful.
It's very pathetic, my objection, madam. This case, madam, the respondent number 4, the owner of the scooty, the sister of the deceased, hearing, and daughter of the claimant's respondent, hearing. Date of death was just before that the date of accident. He was not went for her matrimonial home next day when the accident occurred. Very pathetic. It is, my lord, admitted in the claim application that the 17 years old the deceased was at the time of accident. Your lordship kindly come to page 1.
Yes.
Kazim Badar was also on the pillion side, pillion rider on that vehicle. He was also dead. So, page 1, my lord. Page 1, my lord. Serial number 4. He may be 17 years, my lord, but at the very initiation, my lord, it was stated in para 4, my lord, salesman come manager attached to Roy Shoe Store, situated at Batkulla, Busy Market, Nodia. Next page, my lord, name and address of the employer. Tony Prai of Batkulla, Tahirpur, Nodia. Monthly income 6,000 per month. Para 10. This was driving his sister's motorcycle, non-offending vehicle, along with pillion rider. Here, my lord, 2 insurance companies and 2 owners here where my lord made parties in this case, Creator and New India, and 1 sisters of Mary Immaculate and the daughter of sister of the deceased here, being the owner of the scooty. 6 lakhs per year. My lord, the New India Insurance Company appeared and Oriental Company Insurance Company appeared and they filed written statement. I have, my lord, given the New India and the supplementary paper book, my lord, reflects the written statement of the Oriental Insurance. Here, my lord,
This is the supplementary paper book.
that is, my lord, the written statement filed by the Oriental Insurance Company. That will, yeah. My lord, here is, my lord, the question of contributory negligence, my lord. Regarding, my lord, the question of contributory negligence, my lord, I have to, my lord, submit in that fashion that in the written statement, no plea was taken by the insurance company in specific about the contributory negligence made on behalf of the deceased himself. No specific. Accordingly, my lord, the frame, page 22 of the paper, I could not find could not find any specific issue framed under this act. No specific issue with regards contributory negligence, and also the deceased was minor at the time of right.
No, regarding minor, it is the claimant's case. So for that, no issue is required.
No specific issues framed on this point. Since why not framed? Since the insurance company did not take any steps in their written statement, even after that, my lord, they have not filed any additional written statement. So the learned judge did not think that the issues have to be framed under this. Thereafter, my lord, the claimants produce some papers, including first information report and other, my lord, one police constable were were, my lord, examined in this case, and who, my lord, came with from the criminal court records. That's the two Caesar list, my lord. That is, my lord, exhibit 7 and 8 here, my lord. You will also already produce that from the criminal court records. My lord, in this case, my lord, if minor, my lord, without holding any driving license, my lord, drove the car, my lord, it is, my lord, the penal offense, obviously, under the Motor Vehicles Act and as also under the Indian Penal Code. Police can start there without any hesitation to start a criminal case, my lord, since it is a case of death. But police cannot. Police not initiated any criminal case. But for that reason, my lord, the fathers and parents' claims cannot be denied. It is only a penal provision under the law. Nowhere in the Motor Vehicles Act it is stated that anybody without holding any driving license, even if it was on his or her fault, then the claim should be denied. Nowhere in the Motor Vehicles Act is stated. And your lordship kindly come to the evidence of eyewitness.
Dada, with your permission, my lord will pardon me. One thing I missed out, with my learned friend's permission, my lord. Page 41 is the first information report. There were total 3 numbers of people on that scooty, my lord. Page 41. I missed out this portion. I'm so sorry, my lord. In the middle portion, my lord, your lordship will see. দিকে যাচ্ছিল মোট একটি বাবা এ তো পড়া যায় ওভারটেক করতে আচ্ছা দুর্ঘটনা স্থলে একটি স্কুটি মোটরসাইকেল দিকে যাচ্ছিল এটা কি লেখা দেখুন তো মোট একটি ট্রাককে ওভারটেক করতে যাওয়ায় সো স্কুটি ওয়াজ ওভারটেকিং দ্য ট্রাক করতে যাওয়ায় ঠিক সেই সময় একটি উল্টো দিক থেকে আসা বোলেরো গাড়ির সাথে মুখোমুখি সংঘর্ষ হয় ঘটনাস্থলে দুজন গুরুতর আহত বাইক আরোহীকে তৎক্ষণাৎ আমরা গ্রামবাসীরা হাসপাতালে পাঠাই পরে ডাক্তার তাদের মৃত বলে ঘোষণা করেন আই পজ হিয়ার ফর আ মোমেন্ট সো 2 persons they are already dead এবং পরে একজনকে পাঠানো হলে সে চিকিৎসাধীন অবস্থায় মারা যায় so 3 persons, my lord, which is
it doesn't mean that 3 persons were riding. It is not clear from the first information report that 3 persons were riding at that point of time in a single scooty. So he may be on the spot. It is not clear from the first information report, and even it is, my lord, fact that it is also under the penal provision and violates the motor vehicles rules. My lord, kindly come to page 15. This is the deposition of eyewitness. This is, my lord, not page 70. 17, my lord. This is, my lord, the witness, my lord, came from the police, who, my lord, exhibited two documents, that is the seizure list. And 17B, my lord. PW3, Raju Chandra. The evidence of Raju Chandra, eyewitness, that on the fateful day of accident on 12/12,
Page 17.
Page 17B.
Yes.
17.
Yes.
That is PW3's evidence.
Yes.
Who was only eyewitness in this matter. On the fateful day of accident on 12/12/2016 at about 14:15 hours, while the deceased Somnath Rai alias Shubhajit Rai, driving his sister's scooty bearing number such and such, was proceeding towards Krishnagar side along with pillion rider at a moderate speed, touching the extreme left side of the road very cautiously near Sanghoshri Club at Bhaduri, Noyakhali Para. The offending vehicle bearing number such and such, Bolero car, running at a very high and excessive speed coming from Krishnagar side, proceeding towards opposite direction, lost control and hit the said motorcycle, as a result of which both the motorcyclist and the pillion rider were thrown off the road, received serious injuries. My lord, here, my lord, two persons named. They were taken to Nadia District Hospital, Krishnagar, where the EMO declared both of them as dead. This is true to my knowledge. This is the accident was the result of rash and negligent driving of the above noted Bolero car by its driver only. There was no negligence on the part of the deceased, who was driving the motorcycle of his sister at a moderate speed, touching the extreme left side road very cautiously. This is true to my knowledge. And hereafter, my lord, the cross-examination I have by the insurance company Oriental. I have grocery shop at Tahir. I run my shop myself. I open my shop at about 7:30 p.m. I close the shop at about for lunch, my lord. It cannot be dinner. At about 1:30 noon, I again open my shop at about 4:35 p.m. I did not inform the alleged accident at local police station. Not the fact that the scooty was tied at the relevant time of incident. Not the fact that there was a head-on collision for such conduct of the scooty driver. Police did not meet the spot at the time. By that time, I left the place for hospital with the injured. Not a fact that the Bolero driver was not responsible for the alleged accident. I took the victim to hospital from the spot. I have no document in my custody to show that I took the victim to hospital. I have not received any summon of this court to divorce today. Today I have come to this court after being called mother of the victim. Not the fact that I did not see the actual accident, not the fact that I have divorced falsely in this case. Cross-examination by the New India Insurance Company, the victim had no fault for the alleged accident. In spite of that, both the insurance company not failed to take any steps to produce any documents before the trial court to prove their plea, even at all, at that point of time for them. And also, my lord, failed to produce any witness.
No, OPW1 is.
One is the father of the.
OPW1
That is from RTO, Murshidabad.
RTO
regarding vehicle.
Bolero car.
Bolero car, my lord.
Only OPW1 is examined.
OPW1 is examined. No other witnesses, no documents from their side.
What document will we give? Third.
So they could have produced the records from criminal court, my lord. It is from our side, my lord. We call the police from the court to the court and produced to we gave some list, my lord. The police came with only two papers. That is the both were exhibited as exhibit 7 and 8. That is the, my lord, the seizure list. Not any other documents were came forward to the court, my lord. They, my lord, also failed to call for some records from the criminal court. Call for the IO of the case. To call some witnesses, eyewitnesses of the occurrence. So at this stage, my lord, it is not, they have not made out happily a case for contributory negligence. My lord, it is, my lord, the judgment of the Supreme Court that if any plea taken by the insurance company from the very beginning of the case, my lord, they have to prove that plea in the trial. So contributory negligence point goes in view of settled law. And accordingly, my lord, it is, my lord, that mixing point. So if any person without having any driving license drove his car or scooty, my lord, he is responsible. At that point also goes. So penal provision only can be attracted. It is not proved that any stage of imagination, my lord, no witness, my lord, this witness PW3, no question, my lord, put before the PW3 that he was driving reckless and negligently.
Yes, what is your challenge to the quantum?
Quantum, my lord, rupees 3,000 notional income for non-earning person. Those, my lord, for those are not a non-earning person, my lord. Rupees 3,000 taken here in this case, my lord. It is, my lord, from the very beginning in the claim application, my lord, the employer's name, address, and my lord, the employer's office, and my lord, the avocation, my lord, it is, my lord, stated from the very beginning. And my lord, in the evidence, my lord, the father also, my lord, on the same line. Your lordship kindly come to page 50.
Yes.
Page 15 to 12. Page 12. It is the evidence of respondent number 1, claimant father.
Yes.
He also, my lord, stated in the same line.
What was his educational qualification?
My lord, past 17 years, my lord.
No, where he used to study?
Certificate produced before the trial.
No, 17, you see, 17 a person may pass.
10 pass.
Yes, so was that produced?
No, at least class 10 pass, and your lordship, the avocation was stated as salesman come manager attached to Roy shoe.
Usually 17 pass, 18, you see, they continue their studies. They usually do not go for this occupation.
Sometimes, my lord,
That employer came to depose.
No employer came, my lord.
At best, that could have been some part-time work.
Socio-economic condition of our country shown them.
How 17 years person can work in this way, manager?
Boy, my lord, they are attaching with labor job.
That's a different issue. This managerial work, how this person can do?
My lord, my lord will see in the tea shop besides High Court, my lord.
That's a different issue.
Boys, 10 years.
No. That's a different issue. You see, 12 years boys, 13 years boys, but he is doing some managerial function. 17, how 17 years person?
Village side, my lord.
What type of that person, that employer also did not come to depose?
Yes, shoe shop
Whatever
on the village side. So there is, my lord, no educational
very difficult that this 17 years person will be paid 6,000. It's very difficult to believe.
And my lord, the accident happened in the year 2017. 2016. It is not the case that 2008-9.
2017 very well. 2017 also.
And when it is claim was
had it been some he's doing some educational institution or something, could have considered that issue. No educational qualification certificate stated, 17 years boy doing some managerial function. How is it possible to believe?
Also not challenged happily by the.
Very well, it's very difficult to believe without corroboration. Anyway, so whatever the learned court thought,
And my lord,
the court has considered. No, future prospect, how much?
40%.
40% of the assessed monthly income, and filial consortium, my lord, both the parents, my lord, already 50% deducted by the learned tribunal. Parents here, my lord, the claimants, respondents here. 15,000, 15,000, 30,000 were granted as general damages. And interest, my lord, granted 6% from the date of filing.
So general damages, how much should be? Filial consortium
I leave it to my lord.
plus loss of estate and funeral expenses. If it is one,
I will object as far as the filial consortium is concerned, but I leave it to my lord on that.
Loss of consortium will not be, but filial consortium on the general damages should be granted to father and mother.
no, did you take the point in your grounds that non-grant of filial consortium?
No point, my lord, I can take.
So only your issue is this salary, 6,000 and the future prospect.
Yes. And yes, my lord. And my lord, the Supreme Court in Pune City, my lord, stated that after every 3 years, my lord, it should be increased general damages at a rate of 10%, my lord. That was not considered by the learned tribunal. আবার বলবে রিপ্লাই আবার তুই জিজ্ঞাসা করতে শেষ হয়নি এখন আমাকে
ঠিক আছে, তোমার কিছু বলার নেই, প্লিজ বসে পড়ো। না না, কিছু ঘাড়ে বসে পড়ো।
That's all.
My lord, one line reply, my lord. As far as this our taking plea, whether the victim had license, no license, I am not supposed to. I should not, because in any event he was driving, my lord. He was a minor. He was not supposed to drive at all. So it's against the law that a 17-year-old minor boy was allowed by his parents, my lord, or whoever, and by his sister, my lord, to drive that scooty without a license. They all should be tried, my lord.
They all should be penalized.
Absolutely, because the boy died because of them. Had he not been driving without, perhaps he would have been alive. Well, 17 বছর বয়স, unfortunate. না, that is the কিছু বলেনি.
Yes, record and order. Learned advocates.
My lord, the victim of sisters of Mary
Appearing for?
Immaculate, private respondent, my lord.
Okay.
Owner of the Bolero car.
Owner of the
Yes.
Bolero car. Learned advocates for the parties are present. You are supporting whom? The insurance company?
Yes.
The learned advocates for the parties are present. Heard learned advocates, hearing is concluded. Let this matter appear for judgment on 15/9/2026.
ওই 15 judgment দেবেন. I'm grateful, my lord.
My lord, I would like to file written notes of arguments in respect of this case as well.
Yes.
I would like to submit the written notes of arguments in respect of this, my lord. May I exchange it in the meantime?
You don't
Do it in the meantime in course of the day.
I will, my lord.
I don't have anything against.
I think you are appearing for the first time today in this matter.
Yes, my lord.
You do it in course of the day.
Grateful, my lord. Deeply obliged.
Extremely grateful, your lordship.
My lord, this is a insurance appeal.
Yes. 8 and 9.
My lord, only 8, my lord.
8. Oh, 19 হয়ে গেল 8.
My lord, this is an insurance appeal. This is, my lord, confined only to the quantum of compensation. And my lord, honestly, my lord, we tried to settle, my lord. But somehow, my lord, it didn't work out. My lord, the point involved is, my lord, is very short and crisp, my lord. It is a death case.
There is no counterclaim.
No, there is no counterclaim, my lord. My lord, is a death case. My lord, the victim, my lord, is approximately 49, 50-year-old, my lord. Employee of, my lord, Bharat Petroleum.
Yes.
My lord, victim was, my lord, an employee of Bharat Petroleum. My lord, an award of principal sum amounting to rupees, my lord, 2 crore, 2 lakhs, 21,664. No, 2,02,21664.
Let us see the.
You know, the award of learned tribunal starts at page 21. My lord, the calculation part, my lord, is at page number 57 of this paper book, my lord. And the final calculation is at page 62. If lordship kindly comes to page 62, my lord.
21.
Award starts 21. If lordship kindly comes to page 62, I'll just, my lord, try to make my lord's task a little easier, my lord. Page 62.
Yes.
In bold, your lordship will see at the bottom 202,21664. This is the principal sum. My lord, the calculation part is, my lord, we are not challenging.
Future prospect.
My lord, everything is there. My lord, everything is there. We are not on those. It's only, my lord, with regard to the part of income, my lord, the deductions. My lord has seen, my lord, this sum total 202,21664. My lord, this with interest, my lord, approximately 3 crores is deposited before your lordship's court. My lord, now, my lord, I would invite, my lord, how this calculation has been made. My lord, at page 62, your lordship sees, my lord, the annual income 1860153, the very top.
That is from the income tax return.
My lord, income tax return, my lord, and the, my lord, the form 16.
Yes, that is from income tax
Just,
return.
my lord, form 16. Your lordship will kindly see, my lord. I'll just show, my lord, how it has been calculated and where, my lord, I join issues, my lord. Page 57, if my lord, may I invite your lordship to.
Page 50.
Page 57.
Yes.
My lord, the calculation part starts, my lord, at the last paragraph after careful scrutiny. Lord, I am not taking, my lord, to the nitty-gritties, my lord. Page 57, last paragraph. After careful scrutiny of the Form 16 and Form 12BA of the assessment year 14-15, my lord, date of death is, my lord, 24th March 2016. So, my lord, financial year 14-15 is the last financial year of, my lord, assessment year. This is the of the previous year, my lord, assessment year 14-15. It is perspicuous that in that assessment year, employee Amit Kumar Chaudhary, my lord, he is the deceased, my lord, Amit Kumar Chaudhary, was paid rupees 29,99,000 in total by the employer. Whereas under the salary head in that year, he received 25,54,696. It will not be out of place to mention here that out of the said income in that assessment year, the incumbent had to pay income tax of rupees 710,626. Lord, it is not relevant to us. Lord, what is relevant to us now we are coming to. Again, it protrudes from the careful scrutiny of the Form 16 and Form 12BA for the assessment year 2015-16. Lord, this was considered. 15-16 and Form 12BA for the assessment year 2015-16, that in the assessment year, the employee Amit Chaudhary was paid salary of rupees 24,32,890. Lord, this is reflected at page number 102. Lord, I'll just, so that, Lord, your lordship, it doesn't become difficult to your lordship. Page number 102.
Yes.
Page number 102, my lord, Form 16. It reflects TDS. Your lordship will kindly see, my lord, in the middle, amount paid credited. My lord, fourth or fifth column, my lord, right in the middle, amount paid credited. My lord, there are 1, 2, 3, 4 payments. The sum total is 24,32,890. The employer says, my lord. Is my lord there, my lord?
That is Okay, page 102.
Page 102, my lord. In the middle, your lordship will see the first column starts at quarters.
Yes.
First quarter, my lord, second quarter, third quarter, fourth quarter. Second quarter, my lord, is the receipt number. Third, my lord, third box is amount paid credited. So, my lord, first quarter, third quarter, second, third, and fourth. The sum total of these 4 quarters, amount paid, is, my lord, 24,32,890. This was the salary paid to the victim. My lord, this corresponds to page number 57, the last line, my lord, I was just showing to your lordship too. So that there is no dispute, my lord. This amount paid. We are, my lord, at the item, my lord, on this. No confusion. Page 57, the last sentence.
Yes.
Salary paid 24,32,890.
Yes.
This corresponds to, my lord, this page number 102, 24,32,890. No issues, my lord. I agree.
Total.
Total, yes, my lord. This is the total. Then, my lord, I'm coming back, my lord. I'm just showing, my lord, that why it is correct. It is correct as far as, my lord, the salary paid is concerned. My lord, then, my lord, I'm continuing at page 57, if I may, my lord.
Yes.
It will not be out of place to mention here that out of the said income in that assessment year, the incumbent had to pay income tax of rupees 572,153. My lord, this income tax payment would be reflected at page number 93. That is also correct, my lord. I'll just show it to your lordship.
That means the income tax is adjusted.
Yes, yes, yes. Page 93, if my lord kindly comes to. Page
Yes.
93, assessment year 2015-16.
Yes.
This was the last return filed before the death.
25,97,879.
Lordship, my lord, it varies a little because it may be carrying, my lord, other income also. But as far as, my lord, the salary part is concerned, that I have shown to your lordship from the TDS certificate.
The court proceeded on the basis of salary income.
My lord, minor difference. It will not make much difference.
Okay.
So, my lord, as far as the tax part is concerned,
total tax paid is 5,72,153.
I'm extremely grateful, my lord. That is, my lord, that is my lord, shown at page number 58. That is why, my lord, I had requested my lord to come to page 93. Page 58.
Yes.
So, my lord, the salary is confirmed, no issues. Tax is confirmed, no issues.
Yes.
My lord, I'll continue at page 58. It is the settled law that for considering the income of the victim, income tax to be paid from the income has to be deducted. So, after deducting
Any
the
profession
income
tax?
My lord, I'm not 100, 200 rupees, my lord. Yes, professional tax would be at any event. My lord,
2,000 rupees a year.
My lord, even 2,000 rupees, I'm not worried. Because, my lord, it is 2 crore 2 lakhs.
Yes. So profession tax maximum will be 2,000 in a year.
Maximum 2,000 in a year, my lord. So, my lord, and in any event, my lord, the total tax paid, I have shown to your lordship, page 93, 572,153. I had shown it to your lordship, my lord.
Yes.
Page 93.
Yes.
So, my lord, now I was praying before your lordship to come back to page 58.
Yes.
First para, my lord, the 5th line. So, after deducting the income tax from the gross income of the victim, the annual income for the year 2015-16 comes to rupees 1860,153. This is the annual income. And this annual income, my lord, I had shown to your lordship, my lord, in the award at page number, my lord, 62. 1860,153.
Future prospect was taken into
everything, my lord, 1860,153. So, my lord, I had shown to your lordship, my lord, that annual salary, income tax paid.
Page 58.
My lord, page 58 is the calculation. The last sentence of the first paragraph. After deduction of income tax, it is 1860,153. My lord, and page number 62, your lordship sees the calculation has been made on the basis of 1860,153.
Yes.
These are absolutely clear. And thereafter, my lord, the calculation is there. I'm not joining issues on calculation part. My lord, my problem is this 1860,153, this annual income, my lord, is constituting of what? What the figures? My lord, those figures, my lord, are at page number, my lord, 102.
102.
No, 107, my lord. Page 107.
Yes.
Is my lord there?
Yes.
My lord, this annual salary of, my lord, this 24,90,000 or 25 lakh, whatever that is, my lord, is constituting of what heads? Page 107, my lord. Salary details. Your lordship will kindly see financial year 2014-15, the same year, my lord. That is also not in dispute. My lord, basic salary 5,79,000. Is my lord there, my lord, on that page?
Yes, yes.
Variable DA 4,80,000. Conveyance allowance 15,600. House rent 1,73,000. Milord, now comes Milord the problem area. The bonus Milord is 1,69,000 this year. Then Milord the leave encashment 9,19,000. Other allowances 2,16,000. Milord, my problem is that for this particular year, Milord, his salary, Milord, this was the last salary, Milord, last financial year before his death.
Yes.
His salary, Milord, of this 24 lakhs or 25 lakhs per annum constituted, Milord, bonus, leave encashment, other allowance. Milord, I'm not on basic or DA or house or conveyance. That he is entitled to, Milord. That is the loss of dependency. No issues. Milord, even out of these three, Milord, the bonus, leave and other allowances, Milord, leave allowance, Milord, is very, very, Milord, troubling. Because, Milord, leave allowance, your Lordship knows, Milord, all those service persons, Milord, those who work at any, this is, Milord, the public sector, Bharat Petroleum. Milord, they give the leave allowance, Milord, with an option to the employee that every year, Milord, you get paid leave, Milord, 20 days, 30 days, whatever, Milord, the system of that particular organization is. And, Milord, then they also give an option that you can accumulate these leaves. After a certain period of time, Milord, this accumulation comes to an end. Milord, maybe, Milord, in certain places, Milord, I know that there is an accumulation of maximum accumulation of anything between 200 to 300 days. After that, the leave, if any, Milord, would lapse. It cannot be.
Pay slip was exhibited in this case.
Yes, these all are exhibited.
So pay slips shows leave encashment.
No, Milord, no. Pay slip was not there. This form is there. This is leave encashment. Yes, there is no dispute with other side. Milord, there is no dispute with other side. Milord, what I am saying, that for this annual income of 25 lakhs, 24 lakh 80,000 or 25 lakh 20,000, Milord, that is also not much difference. What I say, this 9 lakh leave encashment is given to you in 1 year. In 1 year, by any means of calculation, this cannot be, Milord, 9 lakhs. Because, Milord, I was just, Milord, discussing before your Lordship, Milord, I was just, Milord, informing my Lord, Milord, this leave encashment, Milord, in these organizations, Milord, what is, to the best of my knowledge, Milord, they are anything between the maximum, Milord, is between 200 to 300 days for the lifetime. You can encash them month-wise, quarter-wise, year-wise, or at the end of your career. When you are retiring, then you can encash in.
What was the age of this person?
Milord, he was 50 years old. 49 plus.
So this was in the 2015, there is a leave encashment of 9 lakh.
Yes, 9 lakh.
And his basic salary is?
Milord, basic salary, the very first, Milord, is 5,79,000. So, Milord, that is why, Milord, I tried to sit with my learned friend. That, Milord, this by any wild imagination, Milord, this cannot be correct. This leave encashment of this 9 lakh odd, Milord. Milord, even others, Milord, if other allowances, though I dispute, but even if I give a, Milord, a walkout on this, 2,16,000 other allowances, the bonus 1,69,000. Even if I give a walkout on this, but even if I, Milord, not argue on this, but this leave encashment, Milord, this is not in, Milord, digestible. Milord, that is why, Milord, I sat with my learned friend, and, Milord, I tried to convince him, and, Milord, that this entire 9 lakh, Milord, is not permissible. You can take 10% or 20% of this, Milord, whatever is reasonable. Milord, he said, Milord, let there be an order of the court. Milord, he is not disputing that. He also agrees to this, that this 9 lakh in a year cannot be a leave encashment. It is just not possible. So, Milord, he said, let there be an order of court, whatever my Lord thinks.
How much leave a person wants to encash?
Milord,
1 month, 2 months,
1 month, 2
3
months. Yes. Whatever.
How much he wants to encash?
Whatever. Milord, 1 month.
Or even 1 year.
Or even 1 year. But, Milord,
and this is not recurring income.
This is not recurring income. It cannot be. So, Milord, or if it is, Milord, it has to be divided into his entire salary, Milord, entire service tenure. If there be any. That is why, Milord, I'll say, Milord, I humbly beseech you. Milord, other than this, Milord, there are no other issues. I have come before your Lordship with regard to these 3 allowances. One is
instead of 9 lakh,
Lordship.
Suppose if it is spread for a particular year also,
Lordship.
Suppose 2 lakh is taken.
Milord, Lordship, Milord, make 2 lakhs and Milord deduct it, and then Milord make the other calculation correct. Milord, I will not.
So leave encashment is not a recurring income.
It is not. It is not.
Of every year.
It can never be the double of the basic income.
Yes.
It is an absolute impossibility. So, my lord, he tried to convince his client, my lord, but the client said, my lord, let there be an order of the court. We wanted to settle it out, my lord, but somehow it did not work it out.
So instead of that 9 lakh, let us proceed on the basis of 2 lakh.
Your lordship, and then, my lordship, make the calculation, my lord, and
So
dispose
you
it of.
give that calculation 2 lakh, 18 lakh 60,000. Oh, 18 lakh 60,000.
My lord, from 18 lakh
2 lakh,
60,000.
if 2 lakh is deducted.
No, not 2 lakhs is deducted. My lord, 7 lakhs is deducted.
No. Okay, 7 lakh has to be deducted.
Yes, yes, yes.
The tax has been deducted on that amount also.
So at the lump sum job side figure koche to.
Tax
The job side to lump sum figure koche na.
Instead of doing that 9 lakh something,
Lordship.
let it be 2 lakhs for that year, leave encashment.
To some extent more, my lord. 2 lakhs only. 2 lakhs. 2 lakhs.
আড়াই লাখ মিলট ঠিক আছে done, let him get advantage মিলট from this মিলট for that particular year instead of 9 lakh something let him get 2.5 lakh that also milut I don't this because milut we are on absolutely at the mercy of your
That is 9 lakh something. What is that?
leave allowance.
Let us see that.
Page 107.
Only leave encashment 9 lakh.
And milut I am not fighting on bonus, I am not fighting on other allowance.
No, those are they are recurring.
Milut I that is why milut I say milut I leave it absolutely.
Okay, that is leave encashment 9 lakh 19,000.
Yes.
Okay.
Let it be not
Okay.
Hey, abare বদমাশি করো না please এরকম করো না just now you said আড়াই লাখ
9 lakh 19,000.
Milut, it is more than it's 3 crore now I have deposited before your lordship. Per year. ভুল ভাল বলো না।
If 7 lakh 60,000 goes, it comes to 11 lakh.
Lordship.
153.
Lordship. Page number 62.
Yes. If 7 lakh goes instead of 9 lakh, 19,363, it should be taken as.
May I suggest one thing, Milord?
Yes.
For the ease of calculation. Milord is at page 62, Milord.
Yes.
Milord, it is the very first Milord annual income is 18 lakh 60,000, which includes Milord 9 lakh 19,000. Milord, instead of 18 lakh 60,000, Lordship, Milord, I go further on his side, make it 12 lakhs, and on the 12 lakhs basis, your Lordship will make the calculation. We will make it. I give him, Milord, further advantage.
Yes, what do you say? There is no cross objection.
No cross objection.
So you give the calculation
Milord,
12
on the
lakh.
basis of 12 lakh, Milord, we will do it. Milord, and Milord, one humble prayer, Milord. Milord, in this case, the victim, Milord, the victim, Milord, he was traveling by a Mahindra Scorpio. This Amit Kumar, Milord. And Milord, this Mahindra Scorpio, Milord, itself, Milord, met with an accident, and Milord, it there was no other vehicle involved. The driver also died. Milord, the seizure list and Milord, the charge sheet, Milord, both says that the driving license could not be seized. Milord, there were a number of casualties, a number of deaths, number of injuries. Different claim cases were filed. In one of the other, Milord, that is on record. Milord, my learned friend would not dispute it. In one of the other claim cases, Milord, the policeman came and stated, Milord, not in this case, and he stated that, Milord, there is in the seizure list, there is no driving license because we could not seize it. That is on record. Learned
driver died.
Driver died. Learned tribunal judge in this case, when insurance company took the plea of driving license, said that insurance company, you could not prove that owner was aware of the fact, like Swaran Singh, that his driver did not have the driving license. So we will not give you any right to recover. You had right to recover, but you could not prove owner was aware of this. On this ground, Milord, my right to recovery was not granted.
Anyway, that.
So, Milord, your Lordship will kindly keep that part open because, admittedly, Milord, driving license.
At this stage, you see, had the trial court granted something, you could have adduced some evidence. It would have been. You have not examined the vehicle owner.
Milord, vehicle owner, Milord, it is there on record that in spite of issuance of summons, he chose not to appear before the court. That is there at page number 24.
Okay, let us see.
It is there, Milord. We have made an effort, Milord. It's not that. Page 24, your Lordship, Milord. At the very top, Milord, page 24. The antagonist, the OP number 1 is, my Lord, there, second paragraph. the OP number 1, namely so and so, did not turn up after receiving notice of this case.
No, that is another thing. Have you summoned him as a witness, vehicle owner?
My lord, their summons were, my lord, issued. He chose not to come. He
Anyway,
chose
where
not
is that observation of the trial judge? Why didn't you pray for warrant? Oh, at this stage.
My lord, I am not at the, my lord, it is not that I had not taken this plea, my lord. My plea is there, my
Let
lord.
me see what is the findings.
Lordship, my lord, page number, my lord, 44 of paper book. Page 44, last paragraph, my lord. Next. Is my lord there, my lord?
Yes.
OP, next is germane to note here that the OP2 has not adduced any evidence in support of its case. Rather, the insurance company tried to rely on the evidence of claimant to establish that the driver of the vehicle had no driving license at the time of accident. The counsel for OP2 heavily banked upon Exhibit 12 is the deposition of Mr. So-and-so, who being authorized by the officer in charge of this police station, deposed in another claim case, being number so-and-so, and disclosed that driving license of driver, namely Pralay Saha, could not be seized in that police case is started by police suo motu after the accident. It is the clear and unequivocal contention of the insurance company that as the driving license of the driver was neither seized by police nor it was produced by the claimant in this case, it is the obvious conclusion that the driver of the vehicle had no driving license. My lord, it has taken note of. Then, my lord, Swaran Singh has been dealt with, my lord, at page number 45, 46, and my lord, with the conclusion that insurance company could not prove that owner was aware of this fact. That is why, my lord, I had taken the plea. It was argued. The evidence was, my lord, there of the other exhibited, my lord. It was there exhibited on the part of the claimant itself that there was no driving license, no seizure, no mentioning, nothing. It is there on record. So, my lord, if I can prove my case, your lordship will kindly grant me that liberty. My lord, I am not saying that I will state where I will jump upon the owner. Owner chose not to appear before the court. It was his vehicle, my lord.
And your
lordship,
plea was there that there is no driving license.
yes, my lord, in written statement, if your lordship wants to see, my lord, since the driving was license.
No written statement was filed by the owner.
No, he didn't. He chose not to appear, my lord.
Anyway, but he did not appear as a witness.
Yes, my lord. In spite of notice, no written statement filed by the owner.
Driver was examined.
No, my lord, driver was seriously injured, my lord. He was not injured.
No. After his recovery, he did not die probably.
No, he did not die. He did not die, my lord. To the best of my knowledge, he did not die.
Driver of the offending vehicle.
My lord, there is one vehicle only one vehicle. Yes, offending vehicle.
Offending vehicle.
Yes.
Although he was injured.
He was injured. He was injured.
Yes, you give the calculations.
Lordship. My lord. Lordship, kindly grant us 2 minutes, my lord. The other actor kagos din na.
কিন্তু 4 টাকাটা কিন্তু ওর উপর ট্যাক্সটা ওখান থেকে মারতে ওটা অ্যাডজাস্ট করতে হবে
রুকো না আমি তো তোমাকে সাম টোটাল 18 আমি তো শুধু 660 এখানে রিলিজ করছি 9 ইনস্টেড অফ 9 কত 9 লাখ কত থেকে তোমার এখানে শুধু 6,60,000 ডিডাক্ট করছি তোমাকে তো 3.5 লাখ টাকা অ্যাডভান্টেজ তো দিচ্ছি আমি লিভ অ্যালাউন্স লিভ ইনক্যাশমেন্টেরও তোমাকে 3 লাখের বেশি অ্যাডভান্টেজ তুমি পাচ্ছ
ট্যাক্সটা তো বাদ চলে যাচ্ছে না 7 লাখের ট্যাক্সটা বাদ চলে যাচ্ছে না
দাঁড়াও ক্যালকুলেশন করি
Yes, let me dictate the order.
Yes,
you
yes.
calculate.
Yes.
Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 10/8/2023 passed by Learned Additional District Judge, First Track 4th Court, North 24 Parganas at Barashat, in MACC case number 821 of 2016. Stop. The case of the claimants before the Learned Trial Court may be summed up thus. Para. On 24/3/2016, at about 15 hours, the victim Amit Kumar Chaudhuri and others were traveling by the offending vehicle bearing number WB26T/1988 Mahindra Scorpio, which was proceeding along NH5 towards Kotok side. Stop. The driver driving his vehicle bearing number WB26T/1988 Mahindra Scorpio with a terrific high speed and in a most rash and negligent manner, endangering human life and safety to others, thereby disobeying and violating all traffic rules and regulations. When the said vehicle came near Neulpur, NEULPUR, in between Pani Koili to Chondi Koili, at newly constructed railway overbridge under Dharamshala police station under Jajpur district. All on a sudden, the said vehicle capsized on the road on left side of NH5 due to reckless driving, as a result of which 3 persons were dead at the spot and other 5 persons sustained serious injuries due to accident. Stop. With the help of local people, the injured persons were shifted to Badachana Hospital, District Jajpur, Odisha, through ambulance, out of which 3 persons expired, including the victim at the said hospital. Stop. Rash and reckless driving on the part of the driver of the offending vehicle bearing number WB-26 capital T stroke 1988 within bracket Mahindra Scorpio was the sole cause of the pathetic accident, which could have been avoided if the driver of the offending vehicle would be cautious in driving the vehicle by observing the traffic rules and regulations at the material time. Stop. Pursuant to the filing of the case, notice was issued upon the opposite parties. Opposite party vehicle owner did not appear and contest the case. Opposite party insurance company contested the case by filing written statement. Evidence was adduced and issues were framed. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 64. Hence it is. The appellant insurance company being aggrieved by the judgment and award passed by the learned trial court has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the respondents claimants. Peruse the evidence adduced and materials on record. Learned advocate for the appellant insurance company submits that in the instant case, the learned trial judge failed to consider the net income of the victim and took into consideration the leave encashment amount also in computing the compensation. Stop. Learned advocate further submits that the learned trial judge ought to have adjusted the leave encashment and then proceeded to compute the compensation. It is also submitted that the learned trial judge erred in not granting the right to recovery from the vehicle owner on the ground that he was not having a valid on the ground that police authority did not seize any driving license, and thus he was not having any driving license. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that although the allowances which a person receives along with his salary should be taken into consideration at the time of computing the compensation under the motor vehicles claim law. However, it is to be proceeded with caution as to whether the allowances which a person receives are all recurring in nature or received at least once or twice during the service tenure. As leave encashment cannot be a recurring income in every year, and the same may be done for few times during the lifetime of an employee, the leave encashment of rupees 9 lakh, how much it was? 9 lakh?
My lord is referring to
Leave encashment.
19,363.
9 lakh, my lord, it is 9 lakh 19,363.
9,19,363.
0.56 paisa.
0.56 paisa is excessive, and it cannot be a recurring income of every year. Thus, it would be just and reasonable to consider a proportionate leave encashment income for a particular year and proceed with the annual income of rupees 12 lakh. Stop. Thus, if annual income is considered as rupees 12 lakh, 1/3 being deducted, which is 4 lakh, the total income comes to rupees 8 lakh. Stop. The multiplier of 13 being applied, the total dependency loss comes to rupees 1 crore 4 lakh. Stop. Future prospect of 30% being added, which is 31 lakh 20,000. The total dependency loss comes to rupees 1 crore 35 lakh 20,000. Further, the general damages should be rupees 36,000. Thus, rupees 1 crore 35 lakh 56,000 is the total compensation which the claimants respondents are entitled to as per arithmetical calculation.
You will also make it 1 crore 40,000, 40
40
lakhs. Because some tax benefits which is not included in my this account.
You see, we are giving 5 lakh is.
Tax.
However, this court is of the view that as under section 168 of the Motor Vehicles Act 1988, courts and tribunals are empowered to award compensation which in the view of court is just and reasonable. This court thinks that the compensation of rupees 1 crore 40 lakh is just and reasonable. Hence, the claimants respondents are entitled to rupees 1 crore 40 lakh from the appellant insurance company, along with interest at the rate of 6% per annum from the date of filing claim case till today. The appellant insurance company, the appellant Oriental Insurance Company Limited, shall deposit rupees 1 crore 40 lakh along with interest at the rate of 6% per annum before the Registrar General within 8 weeks from the, within 3 months from,
Money is already.
okay, within 8 weeks from the date,
Deposited.
within 8 weeks from the date of communication of this
It's not
order.
already deposited.
Stop. In the event compensation awarded by the learned trial court is already deposited, no further deposit be made. The claimant's respondents will be entitled to withdraw the compensation amount upon compliance of necessary formalities. Balance amount along with accrued interest, if any, shall be returned to the appellant, Oriental Insurance Company Limited. Stop. However, with regard to the right of recovery as submitted by learned advocate for the appellant, this court is of the view that as the vehicle owner was not examined with regard to driving license, neither was the driver of the offending vehicle examined, this court does not find any error in the observation, in the findings of the learned trial judge with regard to right of recovery. This appeal stands disposed. Anyway.
My lord, that liberty, my lord, if I can prove my case, my lord,
No,
my
no,
lord,
you see,
formally grounds. My lord.
because you see, had there been some findings also, I could have considered. No findings is there.
Yes, my lord.
Had there been some findings, I could have considered that issue.
Grateful to my lord, my lord.
Huh?
Grateful to you.
Both sides, both sides. Ashik, issue. My lord, this is that matter, my lord, which there's this error of calculation, my lord. There's no cross objection on behalf of my.
So if there is an error, you could have filed review before the trial court.
Probably they wanted to give me fees, my lord. So I do not know. Jokes apart, I do not know why they did not.
Okay.
ক্যানটা আমার স্টে ওটা টাকা জমা দিয়ে দিয়েছি ওটা ডিসপোজ হয়ে যাবে স্টেটা my lord will I have preferred the
The
appeal
ground of challenge, one is the
calculation error, and the other, my lord, I have taken one additional ground that the accident, my lord, it took place between a truck and a container. The container was being driven by the victim himself. He was the driver of the container. So I have taken the ground that there was a contributory negligence on the part of the victim, my lord. But we have not adduced any evidence, neither any issues were framed, my lord. So as far as the contributory negligence ground is concerned, my lord, I leave it to my lord. And I'll just indicate that in the FIR, my lord will kindly see the FIR once. And the charge sheet was also filed against the driver of the offending this truck, which is my vehicle. The FIR is at page 26, my lord.
26.
The written complaint, my lord. This says that.
Is it a head-on collision?
No, this probably what I could gather that my truck, my lord, it was reversing at that time the accident took place. Probably what I could understand from the written complaint. It says that the truck was
Anyway, insurance company did not adduce any evidence.
we adduced, but that is in connection with the driving license of the driver of the offending truck, and
By examining the RTO.
yes, the data entry operator. And we have been granted the right to recover because it was admittedly the case that the driver did not have a valid driving license on the date of accident. So at page 26, my lord will kindly see, my lord, it goes against me. I'm not reading it out, my lord.
Okay.
It says that the truck was reversing and the accident took place. The first information report.
So your ground is all as because although in the charge sheet, drivers of both the vehicles are implicated, but the contributory negligence was not considered.
No, the driver of my truck was held to be
The
responsible.
other vehicle truck was vehicle driver.
Container, the victim was driving the container,
So he was also held responsible.
passed away. He was not held to be responsible. Only my truck driver was held to be responsible. So that is why since two vehicles were there and the manner of accident, my lord, I have taken a ground that the victim was also responsible for this for his accident, and so he contributed. But since I have not adduced any evidence, I must be candid before my lord.
Yes, now come to the calculation.
Yes, my lord will kindly come to page number 75.
Starting 76 main
76. It starts at page 75. The income, my lord, it was considered to be 23,785. That is all right. Then the annual income, my lord, page 76. The annual income.
Yes.
It was 2 lakh, fifth line. It was 2,85,420.
2,55,000.
85,420.
That is also correct.
Yes. Thereafter, my lord, this deduction of 1/4, therein lies the difficulty. That amount, it was after deduction, it was the page, paragraph number 26, my lord will see that calculation portion, 285,420 minus 1/4. So it comes to 214,065. Herein it has been held to be 220,815. Should we give a fresh calculation?
Yes,
My
better
lord.
do that.
My lord, my lord. So just because of that, my lord, the entire calculation,
And regarding general damages, all
70,000 was granted. There is no cross objection. So
everything is considered, future prospect,
everything is considered. And I had also been granted the right to recover in absence of a valid driving license. Interest was also 6%. Income, I'm বলে দিচ্ছি, তুমি লিখতে থাকো income.
Yes, record and order. You
780.
calculate.
My lord.
Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 31st July 2025 passed by learned judge bench 5 City Civil Court Calcutta in MSC case number 518 of 2019. The case of the claimants before the learned trial judge may be summed up thus. On 15/7/2019, in between 5 to 5:30 hours, the victim, namely Rakesh Kumar Roshan, was driving the vehicle bearing number HR 55AD/2922 over NH6 near Monusha Tola Bridge towards Kolkata side from Kolaghat side, at the material time, the reckless driver of truck number WB11C/5406, without giving any signal to move the vehicle backwards, with a rash and negligent manner, dashed the vehicle number HR 55AD/2922 with great force.
6% interest.
As a result of the said accident, the victim sustained severe fatal injuries and it caused his death.
You ready to withdraw balance? Later filing, later.
Rash and negligent driving on the part of the driver of offending truck bearing number WB11 capital C/5406 was the sole cause of the pathetic accident, which could have been avoided at the material time by prudent driving. Top.
To withdraw balance.
Pursuant to filing of this case, notice was issued upon the opposite party. The opposite party, vehicle owner, did not contest the case. Stop. The opposite party insurance company contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 78.
একবার দেখে নাও, একবার দেখে নাও।
The appellant, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. It is learned advocate, hard learned advocate for the appellant and learned advocate for the respondent's claimants. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that learned trial judge erred in not considering the issue of contributory negligence as raised by the appellant. Stop. Learned advocate further submits that the learned trial judge erred in arriving at the compensation of rupees 49,46,256, which
50 lakh?
itself 49 lakh
50,16,256.
which goes to show that the calculation itself is an error. Stop. Have you challenged the entire compensation
Yes,
as a whole?
yes.
Learned advocate also submits that the compensation granted is excessive. Learned advocate for the respondent's claimant disputes the submission of learned advocate for the appellant. Upon perusing the materials on record and upon hearing the learned advocates, with regard to the first submission of the learned advocate for the appellant, this court is of the view that as no evidence was adduced by the appellant before the learned trial court with regard to contributory negligence, such plea cannot be taken at this stage. Stop. Now, with regard to the computation of compensation, this court finds that with regard to the reduction of on the ground of personal deduction, now with regard to adjustment of the annual income with regard to personal expenses, there appears some mistake in calculation. Stop. In the event annual income is considered as rupees 2,85,420 as observed by the learned trial judge, personal expenses of 1/4, which is 71,355, being adjusted, the total annual income comes to rupees 2,14,065. 2,14,065. Future prospect of 40% being added, which is 85,626. The net annual dependency loss comes to rupees 2,99,691. Stop. By applying the multiplier of 16, the total compensation comes to the total dependency loss comes to rupees 47,95,056. the general damages of rupees 70,000 added comes to rupees 48,65,056. Thus, the total compensation which the claimants, respondents are entitled to as per arithmetical calculation is rupees 48,65,056. However, this court is of the view that compensation of rupees 48,50,000 is just and reasonable. Hence, this appeal FMA 21 of 2026 stands disposed. Judgment and award dated 31st day of July 2025 stands modified to the extent that the claimants respondents are entitled to rupees 48,50,000 from the appellant insurance company, along with interest at the rate of 6% per annum from date of filing claim case till today. Stop. The appellant insurance company shall deposit rupees 48,50,000 along with interest at the rate of 6% per annum before the Registrar General High Court Calcutta within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, no further deposit be made. The claimants respondents will be entitled to withdraw the compensation upon compliance of necessary formalities. The balance amount, if any, shall be returned to the appellant insurance company along with accrued interest.
My right to recovery, my lord, at
Okay.
page 78.
With
it's there.
regard to, no, right to recovery, is there any findings?
Yes, yes, page 78.
With regard to the right of recovery, as observed by the learned trial judge, as there is no challenge with regard to the said findings, this court does not think fit to interfere with the same.
I'm grateful, my lord. Deeply, deeply obliged.
Maybe permit to mention one matter, my lord. In the morning I missed, my lord. My name has not been gone down in the order sheet, my lord. So I was there, my lord. Correction.
With the lordship's leave, my lord, if I may just mention, my lord, this is an interim prayer for interim order extension, my lord. The interim order had expired on the 14th of August, my lord. But I had mentioned it last week. Your lordship had directed the matter to come up as to be mentioned. My lord, it's serial number 46 of your lordship's list. 46, my lord. Jindal Steel and Power.
Okay, tomorrow if it is not taken up, you mention.
Very
For the claims.
Yes, hence this appeal FMA 66 of 2017 stands disposed. Judgment and award dated 23/6/2016 passed by learned additional district judge first track court Alipurduar stands modified to the extent that the respondents claimants are entitled to rupees 15 lakh from the appellant insurance company. The appellant United India Insurance Company Limited shall deposit rupees 15 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Such deposit shall be made before the Registrar General High Court, Calcutta within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is deposited, no further deposit be made. The respondents' claimants will be entitled to withdraw the compensation amount upon compliance of necessary formalities. Balance amount along with accrued interest be returned to the appellant insurance company. The appellant will be entitled to cause inquiry by giving the vehicle owner an opportunity of being heard as per the procedure laid down in the case of National Insurance Company versus Leaders the BB. In the event recovery proceedings is instituted against the vehicle owner, all points of law will be kept open.
Okay, I shall pay a special messenger cost, else sent back to the court below.
Okay. Okay, TCR be sent back at the special messenger cost.
7 days I shall pay special messenger cost.
Okay, within 1 week, you deposit. Next, another. Yes, hence this FMA 101 of 2024 stands disposed. Judgment and award dated 31/10/2022 passed by learned additional district judge first track first court Alipur South 24 Parganas in MSC case number 30 of 2016 stands modified to the extent that respondents 1, 2 and 3 claimants are entitled to compensation of rupees 60 lakh. The respondent number 1, Bornani Bishas, will be entitled to rupees 30 lakh. Respondent number 2, Pradeep Shah, is entitled to rupees 15 lakh, and the respondent number 3 is entitled to 15 lakh. The appellant, United India Insurance Company Limited, shall deposit before Registrar General rupees 60 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial judge is deposited, balance deposit be made. The claimant's respondents will be entitled to withdraw their share of compensation upon compliance of necessary formalities.
Obliged, my lord. My lord, your losses kindly direct me to put special messenger cost.
Okay, TCR be sent back upon special messenger court.
আমি টুমোরই দিয়ে দেবো ডিপোজিট চাই। না টিসি ওইটা না দিলে না কোনো কাজই হবে না, বেকার হয়ে যাবে।
Okay, within 3 days you deposit.
For the appellant. Nobody is appearing for the respondent. You can recall, this is an suit for eviction of a licensee, initially initiated by a father-in-law against his daughter-in-law. And my lord, thereafter, during
Anyway, other side is not
other
here.
side is not there, and
In the
resolution,
presence of
and in
other side.
resolution is also there. So it's difficult for me to address before your
The
lordship.
part-heard matter.
Part-heard matter. Your lordship, the matter went to the mediation. Since after the demise of the father-in-law, the plaintiff, the son has been substituted, and the suit was instituted against the daughter-in-law. So after the demise of daughter-in-law, rather the grandson of the plaintiff was substituted. Now it has become after the demise of the father-in-law, the son has substituted. Now the dispute is between the son and the father. The father is the plaintiff in place of his father, and the son is the defendant in place of his mother. So now, but the mediation, you'll also send the matter to the mediation, but the mediation has failed.
Okay.
Now the
mother, it is between father and son.
Father and grandmother. And father is one of the appellants before your lordship, because after demise of the
Original
plaintiff,
his son is
his son
substituted.
and the three sons and the mother and the widow has substituted. So my lord, now the complex of the plaintiff has a little bit of change. But lordship,
One of the plaintiff is the father of the defendant.
Yes, one of the plaintiff is the father of the defendant. My lord, but the mediation has failed. It's a keenly contested matter in both the courts. So my lord, there is a chance of mediation.
Anyway, let it be fixed. Yes, learned advocate for the
Let it be
appellant.
fixed shortly, because the widow of the original plaintiff, he is now more 87 years old.
Because 2 weeks this bail set for
Can it be
circuit.
fixed on Friday in this week? If it is possible, subject to your lordship's convenience.
Not now, after 2 weeks. Learned advocate for the appellant is present. As none appears for the respondents, the matter stands adjourned till 16/9.
Interim order might be only required to
16/9/2026 at 2 p.m.
Interim order maybe.
Interim order granted earlier stands extended for a 16/9 at 3 p.m. The interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Great.
My lord, I am for the appellant, my lord. Others, the
Respondent is represented.
Yes, I am the appellant.
No, respondent is represented.
My lord, Chandrila Alam is the respondent, Union of India. My lord, I already informed yesterday and tomorrow.
Today, because nobody is appearing. Most of the lawyers are not appearing. Let a date be fixed.
But date be fixed, my lord. 3 times that may be fixed. But
anyway, today is circumstances
yes, my lord,
different.
date be fixed, but earlier, my lord. They are the indigenous person, my lord. Lordship is the since that the order 23, order 33, rule 1 and delay application apply. He is the too much incapable of the financial intelligence, my lord. In this regards, my lord, date be fixed.
Matter can be settled before Lok Adalat.
No.
Yes, record an order. Learned advocate for the appellant is present, as none appears for the respondent. The matter stands adjourned till 14/9/2026 at 10:30. No, Monday to 12 p.m. tak. at 12 p.m.
Well, if the permission to earlier is not possible,
2 weeks this bench will not sit due to circuit.
I am get to.
Lordship, I am for the appellant. 3 p.m. fixed. 3 p.m. fixed. 3 p.m. আমি এক্ষুনি ডাকছি যদি স্যার করে তাহলে আমরাও করে নেবো ডাকছি আমি ডাকছি Lordship, kindly passes it over for 5 minutes. I'll call my senior.
এক কাজ করি আমি তাহলে 10 মিনিট 15 মিনিট পরে আসি আমি ওয়েট কাম আফটার 10 minutes. Lord 13, my lord, I beg to appear for the claimant appellants. My lord, last occasion, I sought leave from your lordships to use a supplementary paper book because, my lord, at the main paper book, my lord, I forgot to annex the deposition copy of the witnesses.
Yes.
Advance copy of the supplementary I served upon my lord. Now, my lord, may I start?
Yes.
My lord, my prayer is that the learned tribunal at the time of awarding compensation, my lord, whatever amount was fixed is not just and fair, my lord, on threefold grounds. One is that, my lord, my income in my application I have stated is 20,000 at the relevant point of time because the deceased was, my lord, a pharmacist having a pharmacist license from the concerned authority.
Yes.
But learned my lord tribunal hold that the income as I failed to produce any, my lord, my books of deceased books of account with regard to his medical shop. So the learned tribunal hold is that income should be 6,000. But the learned tribunal did not consider the fact that the widow wife, widow daughter-in-law, my lord, and grandchild is dependent on the deceased. Now, my lord, second prayer, my second submission is that the consolitorium which has been decided by the learned tribunal, my lord, is almost 6,000. Where, my lord, the claimants would be entitled to get at least, my lord, in view of the dictum of the Honorable Apex Court, is 40,000. These are, my lord, twofold ground I have. Now, my lord, first I will take your lordships to the claim application, my lord, which will appear, my lord, in my paper book, page 1.
Yes. Yes, paper.
My lord, page 1. My lord, first is that the claimant details. My lord, column number 1 is the deceased name. My lord has got that.
Yes.
Column number 1 is the deceased name. Column number 3 is the age of the deceased. Now, my lord, column number 4 is with regard to the occupation of the deceased. Now, my lord, kindly turn page 2. Point number 5 and point number 6. Point number 5 is the, my lord, his employer. He is a self-employed having his own medicine shop, which is Bhomik Medical Store. Now, my lord, I have produced a documents which with regard to that shop. My lord, I will take your lordships to that page as well. Now, my lord, 6 is the income which I have stated. Column number 6.
Yes.
My lord, the facts of the case, it's stated page number 4. What is the, my lord, actual facts which I have stated and subsequently proved before the learned tribunal is
you
that
see, your claim was allowed.
my claim was allowed.
How
but
much
the
was you prayed for 8 lakh? How much was
8 lakh.
awarded?
3 lakhs, my lord, is totaling, my lord, awarded to me 3,24,500 with, my lord, applicable interest is 6%.
Future prospect taken?
My lord, future prospect was not taken. Consolitorium only 3 point was taken is add funeral expenses, add loss of estate, loss of consolitorium, which is, my lord, page 86, my lord, kindly take.
Yes.
My lord, the breakup is given. Computation of the amount of compensation.
Yes.
Now, my lord, so far as respondents are concerned, my lord, only, my lord, both of the insurance company appeared in the tribunal and used
Vehicles are involved.
My lord,
2 vehicles are involved.
my lord, what has happened in this case? Both the vehicles collided face to face. Now, my lord, in the investigation, the investigating officer at the time of submitting charge sheet, my lord, is of the opinion that two vehicles are responsible. So he arraigned both the driver of the vehicle as an accused of the instant case. But however, my lord, with deepest respect, the insurance company being a respondent herein, my lord, who is contesting the proceeding over here, did not adduce any evidence, with deepest respect. So far as the...
How many insurance companies here?
There are two insurance
So
companies.
both are appearing?
No, one appearing, another one since beginning, my lord, not appearing. So matter was proceeded ex parte against him. Now, my lord, thereafter I will take your lordships that exhibits, my lord, what are the documents I have exhibited. The FIR adds
no question is, you see, with regard to the findings of rash negligent,
that is not the finding of the learned tribunal.
So what is the finding?
Finding is that the victim offending vehicle is responsible.
No, question is, you see.
Kindly take the, my lord, judgment.
No, question is,
my lord, I take your
claim case is awarded.
Awarded, but the compensation which was given to me is not just and fair.
Anyway, that's a different issue. So you are challenging the quantum of compensation.
To that extent, quantum
yes,
of
no question of going into the facts.
No, I'm not, my lord. I just, my lord, briefly giving a facts.
Anyway, facts are there.
So, my lord, then
your ground of challenge is only the quantum.
Quantum, my lord.
Milord, whatever was awarded, they have received. They only want the increase in quantity.
Yes.
Anyway, so no question of going into the facts of the case.
My lord, then, my lord, kindly take page 80, the judgment.
Page 80.
Page 80 is the starting point of the judgment. My lord, my primary grievances lies at page, my lord, 85.
Yes.
As far as the question regarding quantum of compensation to be awarded, my lord has got it. Last paragraph. It has to be kept in mind that the deceased was about 64 years. There is no, my lord, doubt about that. At the time of accident, as has transpired from PM report of the deceased and from the evidence of PW1, the deceased was a pharmacist cum owner of the Bhumik medical store by profession, and he used to earn 20,000 per month from the said profession. In this case, the claimant has not filed any documents to prove income of the deceased. In the absence of any documentary proof regarding income of the deceased, the notional income should be 5,000 per month at the time of accident. My lord, here my grievances lies. If a person having my lord, the pharmacist license, the learned tribunal, my lord, could have holds that my income should be 15,000, because surviving 4%, my lord, 5,000 can't be. And in the, my lord, oral evidence, my lord, kindly take my supplementary affidavit. At the time of oral evidence also, I have stated, I have been only cross-examined to that extent that I failed to produce any documents with regard to my books of account, that Bhumik medical shop's books of account. Others, nothing was, my lord, question put to me.
That any documents was filed by you with regard to your occupation?
20,000 perhaps is not.
No, any documents that you are doing so and so business.
My lord, that documents I have the deceased employee.
Yes,
my lord.
yes.
My lord, that
his business license.
Page 61.
Page
61 of my paper.
Here, there is no scope of future prospect, 64 years. Yes.
This is the pharmacist license issued by the West Bengal Pharmacy Council.
Okay, now regarding that Bhumik shop, okay, Bhumik.
It's
okay,
stated,
Bhumik
medical store, Purva Mednipur. And then subsequent one is page 62 is the registration certificate.
62. This is issued in 2014.
Yes. No, 1978.
No, this is?
My lord, which one?
No, the certificate issued in which year?
My lord, page.
Okay, this is 1978.
Yes.
And Bengal Pharmacy Council, this is
the, my lord, actual original, my lord, it's that license.
Original license.
Yes.
62 is the certificate.
It is the, my lord, after renewal perhaps. Saler renewal fees 31st March 2020 is the last renewal, my lord, perhaps. But admittedly, my lord, I produced those documents before the learned, my lord, tribunal. And the next one is with regard to my payment of fees, my lord.
page 63. And if your
These
lordship,
documents were exhibited.
will kindly take page 5 of my supplementary paper. My lord, I am reading chief of PW1, who is a claimant number 1, appellant number 1 before your lordship.
Yes.
My name is Sagorika Bhaumik. My lord has
Yes.
got that. My lord, the second paragraph, fifth line from the bottom, my lord, in the second paragraph. I have filed one original certificate of pharmacist of my husband being registered.
Page,
My lord,
five.
page 5 of my supplementary paper book.
Yes.
Fifth line from bottom.
Yes.
In the of second paragraph.
Yes.
My lord, the line start, my lord, I have filed original certificate of pharmacist of my husband. My lord has got that.
Yes.
Being registered number D so and so, issued by the West Bengal Pharmacy Council, dated so and so. This marked as Exhibit 8, objected to. But there is no observation by the learned tribunal with regard to that document. If the learned tribunal only was of the opinion, my lord, as I fails to produce any documents with regard to 20,000 of my income. So, my lord, my income, notional income
was considered to be 5,000.
5,000. Lord, that should be increased, my lord, depending upon the, my lord, facts that how many dependents I have at the material point of time. 2 widow, 1 grandchild. Because my son also passed away. So
Yes,
I have a
Mr. Singh.
My lord, learned tribunal, my learned friend, my lord, has shown at page number 85, wherein, my lord, the issue of monthly income or, my lord, the income of the victim was dealt with. At the cost of repetition, would it be my lord's pleasure, my lord, to come to page 85, the last paragraph? Is my lord there, my lord?
Yes.
As far as question regarding quantum of compensation to be awarded, it's to be kept in mind that the deceased was about 64 years at the time of accident, as has been transpired from
Page 85.
Page 85, my lord, the last paragraph.
Yes.
Can I read it again, my lord? As far as question regarding quantum is concerned to be awarded, it's to be kept in mind that deceased was about 64 years at the time of the accident, as has transpired from post-mortem report of the deceased and from the evidence of PW1. The deceased was a pharmacist, come owner of Bhaumik Medical Stores by profession, and he used to earn rupees 20,000 per month from the said profession. In this case, the claimant has not filed any document to prove the income of the deceased. My lord, no, admittedly, my lord, no document. My lord, the widow also has admitted that no document. In the, my lord, next page, absence of any documentary proof regarding income of the deceased, the notional income should be rupees 5,000 at the time of accident. My lord, this is it. Now, my lord, the evidence of widow, my lord, if my lord kindly comes, my lord, to the supplementary paper book. Page number 5, my lord, was shown to your lordship, my lord. I was again inviting your lordship to page number 5.
Yes.
Cross-examination, my lord, at the bottom half.
Yes.
My lord, there, my lord. I have not seen the accident. I have not filed any testimonial of my husband. I have not filed the books of accounts of Bhaumik Medical Store. It is not a fact that at the time of death, my husband was not aged 64. And then again, my lord, it is not a fact that I have already falsely stated that my husband used to earn rupees 20,000. My lord, now, my lord, these are the things. I have put in the question that your husband was not earning 20,000. She said, no, I have not stated.
Question is, trade license of Bhaumik Medical Stores not filed.
Not filed. My lord, now.
This was not filed, only my.
What was filed then?
My lord, pharmacist license of my husband.
No, that is there. Regarding that shop.
Yes,
Page
trade license was not filed.
My lord, page 61, your lordship will kindly come.
Page 61.
Yes. Over there,
that is there. License is there. Registered pharmacist and the degree that is there.
Why it was not produced? Perhaps the answer is, my
question
lord,
is whether Okay, page 61 is West Bengal Pharmacy Council.
My lord, kindly see the professional address, the column number.
Okay, Bhomik Medical Stores.
Written. That is the reason, my lord, trade license was not produced by me.
My lord, be that as it may, my lord, I'll just
Documents
indicate
was
to your
not
lordship.
challenged.
My lord, what was there, it has been shown to your lordship. My lord, what is not there, that has been dealt with by learned tribunal judge. Trade license is not there. My lord, a person who is earning 20,000 rupees per month, my lord, the law doesn't bar him from filing his returns. My lord, you're not supposed to file tax, I understand. But 139(1) is very clear, my lord, one is supposed to file his returns. You say your income was to the, my lord, to the tune of approximately 2,50,000 per annum. You chose not to file your income tax return, and now you claim that yes, your income was 20,000 rupees per month. My lord, this liberty should not be granted. My lord, this is the second part. Third part, my lord, there is no evidence that this shop came to a close. There is absolutely no loss of dependency, my lord. The person died, the shop is running. Now, my lord, this is, my lord, first of all, my lord, as at the cost of repetition, my lord, no trade license was given. Secondly, my lord, the income tax, my lord, was deliberately not shown. Or, my lord, it was not filed rather, my lord. Had they filed, my lord, then I wouldn't have been, my lord, arguing this case before your lordship. Thirdly, my lord, there is no evidence that the shop came to close. And fourthly, my lord, three major sons are there. The person, my
But
lord,
can they run the shop without that council, the register and pharmacy?
there is, my lord, there
That
is,
certificate?
my lord, there, but my lord, as far as the dependency part is concerned, my lord, the
No,
three
without
major
that,
sons-
no, it is not a grocery shop. Okay. So without that pharmacy certificate, whether the dependent.
That is true, that certificate would be required. Certificate would be required, my lord, but there is no evidence with regard to anything regard to that. The shop has come to a close. My lord, I simultaneously say there is no evidence as well that the shop has come to a close. My lord, then thereafter, my lord, no books of accounts. That is admitted part has been shown. Even the bank account, my lord, would have been more than sufficient to show that yes, he was earning whatever the earning was, my lord. I do not know, my lord, whether the shop was being run or not. It's only oral evidence, and against oral evidence, my lord, I give, my lord, 1, 2, 3, 4, 5, my lord, the replies that to prove your income, you are coming to the court, you are asking for, my lord, this compensation, and you are not coming to the court with a clean hands. You are not showing your books of accounts. You are not showing your bank accounts. You are not showing what transactions you were having. You are not showing that what was your income. Only, my lord, the oral submission in every single case would not do. You were already 64. My lord, in all government posts, my lord, or government organization, my lord, you are not allowed to, my lord, after 60, you are retired. As far as pharmacists are concerned, that is the maximum age limit. I understand you were self-employed, but still, you claim to be self-employed. You came to be, my lord, you chose, or you, my lord, you claim that you were running the shop. Give the documents of your income and claim whatever the income was. You decided not to, and only on the basis of oral submission, my lord, the sympathy is being taken from the court, or my lord, is being asked for, prayed from the court for asking for enhancement, my lord. Learned tribunal judge, my lord, has gone into each of these aspects and came to a finding. My lord, these witnesses were before the learned tribunal judge in the witness box. My lord, the widow was there, the daughter-in-law was there, the questions were asked, no documents furnished, and on that basis, my lord, 5,000, not even 3,000, 5,000 was considered and was granted. As far as future prospect is concerned, my lord, the
age will not.
My lord, that is not permitted, my lord, as per penalty. My lord, as far as, my lord, this consortium is concerned, he is right, my lord, 40,000 can be granted against 9,500, which was granted by the learned tribunal judge. My lord, the total general damages, my lord, that was 9,500. In that place, it could be 40,000 or 48,000. That I agree, he is correct to that part, my lord. But as far as the enhancement is concerned, in this particular course, my lord, your lordship will kindly, my lord, not, my lord, grant any further enhancement, my lord. It is not, my lord, only on the prayer of sympathy, my lord, when no evidence is granted, when they could have shown, they chose not to, then, my lord, this sympathy factor should not play in every single case. And, my lord, these are the facts, my lord, and only on this issue, my lord, the case is before your lordship.
Yes, take down. Learned advocates for the parties are present. Hard learned advocates. The appellant before this court were claimants in a case under section 166 of the Motor Vehicles Act 1988 and are aggrieved by the judgment and award dated 29th day of January 2025 passed by Learned Additional District Judge RD Court at Paschim Medinipur in MSC case number 107 of 2016. Stop. The case of the claimants, appellants before the Learned Trial Court may be summed up thus. Next paragraph. On 25/10/2015, at about 14:30 hours, the deceased Shubol Bhomik and along with others were traveling by a vehicle bearing registration number WB42H/7485 within bracket Travera through NH6 Bombay Road, and the deceased started his journey from Kharagpur and his destination was Panchkura. When the said vehicle reached at Krishnanagar near Kalu's hotel, at that time the offending vehicle bearing registration number WB 29 capital A stroke 6466 within bracket truck was coming from opposite side from Debra side towards Kharagpur side through NH6 Bombay Road, being driven by its driver at a high speed and in a rash and negligent manner. As a result, the driver of the offending vehicle bearing registration number WB 29 capital A stroke 6466 truck lost his control over the said vehicle and dashed the vehicle bearing number WB 42 capital H stroke 7485 from face to face, and as a result the deceased Shubol Bhomik alias Shubol Chandra Bhomik and others sustained grievous bleeding injury on his person, on their person. Stop. Next para. Immediately after the accident, the deceased Shubol Bhomik alias Shubol Chandra Bhomik was admitted to Midnapur Medical College and Hospital with the help of local people. Stop. The medical officer of Midnapur Medical College and Hospital declared him dead. Stop. Next para. The accident took place due to rash and negligent driving of the driver of the offending vehicle bearing registration number WB 29 capital A stroke 6466 truck, who drove the vehicle violating traffic rules and endangering the safety and security of others. Stop. Pursuant to filing of the case, notice was issued upon the opposite parties. Opposite party vehicle owners did not appear to contest the case. However, opposite parties, two insurance companies, contested the case by filing written statement. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose the claim case by observing and directing as follows. Page 86. 86, 87. The appellant's claimants, being aggrieved by the quantum of compensation awarded by the learned trial judge, has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the respondents. Respondent, United India Insurance Company Limited. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that although the claimants filed relevant documents before the learned trial court about the qualification of the victim, and although the claimants furnished the total number of dependents of the victim, but the learned trial judge, instead of considering the monthly income of rupees 20,000, has considered the monthly income of rupees 5,000 of the victim. Stop. Learned advocate submits that the compensation awarded by the learned trial court is meager and the same should be enhanced. Learned advocate for the respondent United India Insurance Company Limited submits that the claimants appellants have neither filed their income tax return nor filed any accounts book showing the business transactions, nor filed any other bank passbooks from which the income of the victim could have been ascertained. Stop. Learned advocate submits that the learned trial judge considered the evidence and the documents submitted by the claimants appellants and have arrived at the conclusion of awarding rupees 5 lakh. Stop.
5,000.
Oh, considered the monthly income as rupees 5,000. Upon considering the submissions of the learned advocates and the materials on record, this court is of the view that although the appellant's claimants could not furnish any income tax return, bank passbook, or books of accounts of the business, but considering the documents submitted with regard to the qualification of the victim from West Bengal Pharmacy Council, the mention of the professional address at Bhomik Medical Stores, Purbo Mednipur, and the receipt issued by the Directorate of Drugs Control, where the name of the shop is mentioned as Bhomik Medical Stores. This court is of the view that the fact that the victim was running a medicine shop cannot be ignored. Stop. Thus, considering the nature of the business, the age of the victim, and the number of dependents which the victim had, this court is of the view that it would be reasonable to consider the monthly income of the victim as rupees 10,000. Stop. In the event the monthly income of the victim is considered to be 10,000, the compensation awarded by the learned trial court should be doubled, and instead of rupees 3,24,500, the same comes to rupees 6,49,000. Stop. Further, considering the general damages granted on the loss of consortium, this court is of the view that the total compensation of rupees 7 lakh is just and reasonable. Stop. Hence, this appeal, FMA 12 of 2026, stands disposed. Judgment and award dated 29th day of January 2025, passed by learned Additional District Judge, RD Court at Paschim Medinipur, in MSC case number 107 of 2016, stands modified to the extent that the claimants respondents are entitled to compensation of rupees 7 lakh from the respondent number 1, United India Insurance Company Limited. Stop. The respondent United India Insurance Company Limited shall deposit before the Registrar General High Court, Calcutta, rupees 7 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. In the event compensation awarded by the learned trial court is paid or deposited before the Registrar General High Court, Calcutta, the balance amount of compensation be deposited.
My lord is dictating that in the event compensation already paid.
Paid or deposited.
My lord, paid or deposited.
Or deposited.
We have paid in the court below and they have
withdrawn. That's a record. Paid or deposited. The balance amount, the balance deposit be made. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. The appellant's claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. Stop. The deficit court fees on the enhanced compensation be paid before the learned trial court. The trial court records be sent at the special messenger cost of the respondent of the appellant's claimants to be deposited within 1 week. Grateful. Yes, sir. Deficit court fees to be paid before the learned trial court within 4 weeks.
We are obliged, my lord.
Grateful. Grateful.